In public session, and the purpose of our session this morning is to, well, it's our first session this morning, is to consider a government motion to exercise the right to opt in pursuant to Protocol 21 of the Treaty on the Functioning of the European Union, I believe also known as the Lisbon Treaty, to a measure in the civil justice area. The proposal is to accept Colm 2018-472 of the European Parliament and of the Council, a regulation establishing the Internal Security Fund. In welcoming the Minister here for the first session this morning and his officials, I have to, at the outset, caution members, all members, the Minister as ex officio. All members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or identifiable. Now, just before bringing the Minister in, I just want to remind everyone, including our guests, that mobile phones should be switched off, please. So I now invite the Minister to make his opening statement.
Thanks, Chair. I'm very pleased to bring what I'm sure members would agree is a good news story or a positive initiative on the part of the Department of Justice and the EU. I'm joined by officials Donald Clare and Patrick McCabe, and as you'll be aware, Chair, the purpose of the motion is to seek approval of the Oireachtas to exercise Ireland's options under the 21st Protocol annexed to the Lisbon Treaty in respect of the proposal for a regulation of the European Parliament and the Council establishing the Internal Security Fund. Events, Caoimhghín, of the last few years unfortunately demonstrate that security threats have intensified and diversified across the European Union. The nature of these threats has not remained static and has evolved. We see today that the threats European citizens face are increasingly cross-border in nature, meaning that Member States must cooperate. The European budget can support Member States as we work to keep our citizens safe and together build a union that is resilient to future security challenges and is better equipped to respond to emergencies as they arise or that may arise. The continued attractiveness of the European Union as a politically and economically stable place in which to live, travel and do business depends greatly on its reputation as a genuine area of freedom, security and justice. Among many other things, this requires that we minimise the threats from terrorism and from serious cross-border criminality, including the scourge of terrorism, the ongoing menace of organised crime and new frontier of cybercrime, which can have potentially devastating consequences for business, individuals and IT security. Ireland has always been and will continue to be an enthusiastic and proactive supporter of cooperation across these areas. The objectives of the Internal Security Fund are based on the scope of its predecessor instruments, the Security and Safeguarding Liberties Programme for the period 7 to 13. The Instrument for Police Cooperation, Preventing and Combating Crime and Crisis Management, ISFP, which was established by Regulation EU 513 of 14 and formed part of the Internal Security Fund in the period 14 to 20, and the Drugs Policy part of the Justice Programme established by Regulation EU 1382 of 13 in the period 14 to 20. All of these imperatives require financial support for the development of closer cooperation between law enforcement authorities for the exchange of personnel, ideas and best practice. Ireland participates in the current ISF regulation, ISFP, for the period 14 to 20. The current ISF fund has enabled high-volume investments, especially in IT systems, from which Ireland has benefited. For example, Ireland's connection to the fixed Interpol network database for linked member countries to access Interpol's global databases. Under the current ISF, An Garda Síochána act as both the responsible authority and the audit authority. My department regularly reviews expenditure under the current ISF fund in Ireland through the ISF Monitoring Committee. The Monitoring Committee is comprised of officials from both my department and An Garda Síochána, works to ensure that Ireland achieves the maximum benefit from our allocated funding in full compliance with European Union law. Just briefly, the main features, Caoimhghín members, if I can. The future ISF structure will contain a single general objective, which will be to contribute to ensuring a high level of security in the Union, in particular by tackling terrorism, radicalisation, serious and organised crime and cybercrime, and by assisting and protecting victims of crime. This reflects the Union's security policy. The overall objective is supplemented by the following three important horizontal objectives. Firstly, to increase the exchange of information among Member States' law enforcement and other competent authorities and other relevant Union bodies, as well as with third countries and international organisations. Secondly, to intensify cross-border joint operations among Member States' law enforcement and other competent authorities in relation to serious and organised crime with a cross-border dimension. And thirdly, to support efforts at strengthening the capabilities in relation to combating and preventing crime, including terrorism, in particular, through increased cooperation between public authorities, civil society and private partners across Member States. These are important objectives for all Member States and the Union as a whole. Ireland welcomes the commitment to enhancing the safety of all our citizens by improving the capacity of Member States to engage in active cooperation. Reflecting the increased threats faced by European citizens and the intended increased need for Member States to work collectively to fight such threats, an important development in the proposal for future ISF is the Commission's intention to multiply Union funding for internal security by a factor of 1.8. The financial envelope of the Internal Security Fund in the period 21 to 27 will be 2.5 billion in current prices, euro. This increase in funding is welcome and demonstrates the Union's determination to be a place of safety and security for all Europeans. The main challenge the proposal aims to address is the need for greater flexibility in managing the future fund, along with tools to ensure that funding is steered towards EU priorities and actions with a significant added value to the Union. The funding is implemented through shared management by Member States, direct, indirect management by the Commission. A new thematic facility comprising €1 billion will be allocated periodically, allowing the funds to, at the initiative of the Commission, support targeted actions by Member States and allow for a rapid response to immediate security challenges or emergencies. The programming of actions under the thematic facility would be implemented through annual and multi-annual work programmes adopted by the Commission implementing decision. This new thematic facility will make it possible to address new priorities, take urgent action and to implement them through the delivery mode that's best placed to achieve the policy objective as time progresses during the period of the funds, which is 21 to 27. Allocations under the future Internal Security Fund will be based on a 60-40% split. 50% or 1.25 billion will be allocated to Member States initially, with a later mid-term allocation of 10%, 250 million. The remaining 40% of €1 billion will be assigned to the new thematic facility. Each Member State will receive a one-time fixed amount of €5 million to ensure a critical mass at the start of the programming period, plus an amount varying according to a distribution key weighted on the following criteria: 45% in inverse proportion to the gross domestic product, 40% in proportion to the size of the population of the Member State, and 15% in proportion to the size of the territory of the Member State. Importantly, this proposal, Caoimhghín, also sets out the general principles that expenditure under the ISF must be consistent with EU policies and priorities, must be implemented in close cooperation between the Commission and Member States, and must, of course, be subject to sound financial management. The proposal also contains provisions on management and control of the fund. The proposal makes provision for the inclusion of the Union Agency for Law Enforcement Cooperation, Europol, the European Union Agency for Law Enforcement Training, CEPOL, and the European Monitoring Centre for Drugs and Drug Addiction, EMCDDA, in the process of developing Member States' national programmes, and for these agencies' participation in monitoring and evaluation tasks under the proposal. Member States will be required to submit annual performance reports from 2023 onwards. I'm confident, Caoimhghín, these measures and others will be further set out by the Commission in implementing acts which will ensure that the future ISF achieves its objectives and delivers the maximum benefit for European citizens across the Union. This proposal, while largely technical in nature, provides an effective foundation for the Internal Security Fund for the period 21 to 27, and this, of course, is to be welcomed. The proposal doesn't present any fundamental policy difficulties for Ireland, and the AG's office has advised that it sees no legal impediment to opting in to this proposal. I'm strongly of the view, Caoimhghín, that Ireland should participate in the adoption and application of each of these proposed measures. In doing so, Ireland will be in a position to benefit from financial assistance in pursuit of the various forms of police cooperation to which the proposed measures relates. Our participation in the adoption of this measure will also enable Ireland to have a say in their final content, including particular budgetary allocations within and between each measure. Opting in at this point does not necessarily imply that all elements of the proposal are completely acceptable to Ireland, but simply that we support the substance of the proposals and wish to participate in their negotiation and adoption. Opting in now will lend weight to any policy positions that we may take during the negotiation process and allow us to maximise our influence in the final shape of each of these regulations. I hope the committee can support the exercise of Ireland's opt-in in respect of this proposed regulation. Thank you, Caoimhghín.
Well, my good Minister, and just before bringing in members who have indicated the process this morning is a consideration. We don't have to make a decision as a committee. That's for the houses themselves. The first to indicate was Deputy Donnchadh, please.
Obviously, cooperation in relation to security and tackling crime internationally and so on is very important. However, this is a substantial fund, and it's one which is different in a number of respects from the previous fund, from the 2014-2020 programme. I have a number of questions and then maybe some observations, but if you can answer the questions as briefly as you can. What is expected to be the Irish contribution approximately to the new programme, financially?
Well, the Irish contribution, we're now a net contributor to the European Union. So it would be difficult to specify what the Irish contribution to this fund will be, because we're actually benefiting. So this fund will actually be drawn down by Ireland. In terms of our contribution, this must be seen as part of our overall EU contribution. So it isn't possible to identify how much we will be contributing to this particular scheme or programme. Rather, what we will be drawing down in terms of the benefit of the scheme towards us, which will be a total of €9 million over 9 programmes.
It seems to me difficult to imagine how we couldn't calculate that. I don't know, maybe you don't have it right now, but yes, there is a general overall allocation to Europe, but presumably if countries can opt out, then the calculation of what the budget of the fund will be, then, if they're able to do it centrally in Europe, surely we should be able to figure out roughly what we will be contributing to this. And, no. We may be net contributors to the EU, but will we be net contributaries or beneficiaries of this particular fund?
It's beneficiaries, Minister, in this
yes.
instance. Isn't that the case? Yeah. It's going the other way.
Yeah. It's a fund that within the European Union of a total of €2.5 billion, and we will benefit under that scheme. We won't be making a contribution to the fund as such.
We'll be making a contribution to the EU budget that...
Which we do anyway.
Yeah, I know.
Yeah.
All right. Very well. And I'm sorry. You mentioned that there's an audit committee for this internal security fund. How often has that audit committee met during the lifetime of this current programme?
Yeah. Well, there are 2 committees will be involved here. There will be the Domestic Garda Audit Committee, which will be engaged in the monitoring of the spending of the money domestically. But like all EU funding, there are strict EU audit guidelines. In this regard, there is a specifically designated monitoring committee which will be chaired by an official in my department. And that will be charged with responsibility of monitoring the funding, working closely with the Garda Síochána on the matter of the funding. This body will remain in close contact with the audit committee of on Garda Síochána. So we have both internal auditing and monitoring and external. And members will be aware, Chair, of the need at all times to strictly comply with EU audit monitoring regulations. As regards how often this committee will sit,
well, have met.
Hasn't been said as yet.
No, but there is a standing audit committee for the current programme. So I'm asking how often has that met, past tense?
It meets on a regular basis and keeps in constant contact with Garda Síochána and any other interested bodies. Yeah.
But you don't know. You don't have that information to hand. How often it's met?
How often it sits? Yeah, meets at least on a quarterly basis, I'm told.
Okay, all right, thank you very much. Am I right in understanding that a stated objective, this fund is substantially bigger than the previous fund, between 84 and 112% increase in overall funding? I believe that the increased budget is partly aimed at increasing the flexibility of the fund to accommodate targeted actions as agreed by the Commission, and that there will be €1 billion allocated to that fluid part. My understanding also is that under the single rule book this will allow interworking of this fund with other projects and programmes of the European Union. Would it be fair to say that that could include projects undertaken which would take in elements of the common security and defence policy, of Frontex and the integrated border management fund? Is that fair to say?
Yeah, we sought advices from the Attorney General's office as far as the scope of our opting in is concerned, and we're quite satisfied that this is in line with what we have agreed in terms of close cooperation with our EU partners. My recommendation to the Houses of the Oireachtas is that we opt in to this fund, and it's entirely within the scope of our membership of the European Union and our engagement in terms of security cooperation and defence.
I'm not sure that's really a very direct answer to what I was asking. Like, is it possible to use monies from this for the fluid element, that €1 billion there, for the Commission to advance projects that are related to the common security and defence policy, or Frontex, or the integrated border management fund? Is it within the scope of the Commission? Because the Commission, as I understand it, is responsible for these targeted actions under this project. Is that possible?
The ISFP has one objective with two security-specific objectives, and that is better exchange of information and increased operational cooperation. We have concerns at certain aspects of the proposals. However, we're quite satisfied that the use of the funding, as far as we're concerned, will not extend beyond what Ireland's association with the European security and defence is.
I still don't think that's very, like, if it's possible, like, there are 3 specific projects or 3 specific policies that have outlined. Can monies from the ISF be used for projects that have a crossover with those 3 projects? I think it's a reasonably straightforward question.
That may be as far as the whole fund is concerned, but not in terms of any drawdown that Ireland has.
Okay, but obviously, like, I mean, you may be net contributors, but like by opting in, we're supporting the potential expenditure of that money too, either directly or indirectly. Just my last question is, what is the... sorry, I have two more questions. You mentioned some concerns. Can you elaborate to the committee what concerns the department has and how you might see those rectified in negotiations? And secondly, what would you intend to spend the monies that Ireland would draw down on for the coming programme?
Yeah, well, I have to say that currently the proposals are at a very early stage. There is and has been a general welcome across EU states. Some states have indicated that they are not particularly happy with every aspect of every proposal. At present, as far as Ireland is concerned, we don't have any particular concerns with the proposal as currently drafted. However, we very much welcome the inclusion. We're very anxious to become involved early in the process, and that's why I would be hoping to have the approval of the Houses of the Oireachtas by the 2nd of October, which is next week, in order that Ireland signal its early intention to become involved in this architecture. We are particularly keen to ensure that the relationship between the Union members and third countries is established early and intensified. The reason for that is the impending withdrawal of our nearest neighbours, the UK, from the European Union. So what we're seeing in this fund and the manner in which this fund operates is a greater concentration or a greater development of relations between the European Union and third countries, having regard to the fact that the likelihood is that the UK will be a third country. We don't have any concerns at present, but our monitoring of our own engagement and involvement with the rollout of the proposals, once we're at the table, we will be able to ensure that Ireland's voice is particularly heard and our influence brought to bear. But as far as the government is concerned and as far as the Attorney General is concerned, nothing that is proposed now is an issue that can cause any concern to Ireland in terms of our relationship in European security and defence. And of course, any changes in that would be subject to the ratification by Dáil in any event.
Okay. I'll finish up on this. Right, firstly, I think the second element of that question wasn't really answered in terms of what we intend to do with any money that we draw down. Secondly, you've outlined the fact that you've concerns. I'm not sure it's crystal clear to me what the concerns are. And just in a general sense, my concern is that there seems to be a substantial element of this fund that the European Commission could decide to spend in fairly any way it wishes, or to direct in any way it wishes, so long as there's some sort of security element. But I would have a concern in relation to that. I'll finish that.
The thing to remember is that they could do that if we don't decide to opt in.
That's fine.
Okay. Deputy Mick Wallace to be followed by Deputy Jim O'Callaghan, please.
Minister, you talk about being eager to be involved in the process as early as possible. Have any Irish ministers or officials been involved in the proposals that have been put forward to date? Have you been involved?
Yes, our Irish officials are very much involved. I'm involved at Home Affairs level with the European Council and subcommittees thereof. As far as the monitoring of this issue is concerned, Ireland has a seat at the table. Is very much actively involved at working group level. And also in respect of the subcommittee, the subcommittee on financial instruments of the Justice and Home Affairs, through our office in Brussels and also directly from Dublin.
Minister, you made you stressed on 2 points which you talked about there, about enhancing the safety of all EU citizens, and you talk about the need to minimise the threat of terrorism. In light of this, when you've been involved up to now, has there been any talk about the fact that, a lot of the threat of terrorism is perceived to be coming from extreme elements from certain regions of the world, and I'm wondering, was there any talk about the fact that UK and France are presently arming the UAE and Saudi Arabia, where both of whom are involved in probably one of the worst humanitarian situations on the planet at the moment in Yemen? Has that been discussed?
I haven't been party to any discussions on these issues. Rather, I think that would be an issue more particular to my colleague, the Minister of Foreign Affairs. But I have to say that the government gives the highest priority to the security of the state. And obviously, while there hasn't been, or while there isn't any specific threat to Ireland from international terrorist organisations, as I said before, Chair, there's no complacency in this regard, and it's incumbent on our authorities to ensure that we take all the necessary security measures which are proportionate to any threat. And that's why Ireland's opting in to the availability of this fund will certainly increase our capacity in terms of the sharing of information, in terms of ensuring that we are best placed, along with our EU colleagues. Gardaí and Army continue to carry out regular focused training exercises separately and together, often discreetly and sometimes in public, in order to ensure that we're prepared. But on the specific issue of the policy choices of our EU colleagues, that's not something to which I've been a party to.
Right, Minister, you say that if we opt in, we'll probably be in a better position to have influence, and that's true to a certain degree. But if we opt in, I mean, are the Irish government, I mean, if you are actually worried about the safety of EU citizens, if you are worried about minimising the threat of terrorism, do you not think we should try and stop the wars that are going on around the world? That we should, if we're going to opt in, that we should be working for peace in order to reduce terrorism? That we should be challenging the UK and France, who are supplying the Saudis and the UAE with arms that are creating untold destruction in Yemen. Would the Irish government be prepared to challenge the UK and France in this area, if you did opt in?
Irish government maintains strong bilateral relations with the UK and with France. These may be issues that form part of our discussions on a bilateral basis from time to time. But as far as this issue is concerned, from my perspective, this is an instrument on internal security funding. There is no aspect of this that is related to any defence or military purpose. The UK is not participating. The UK is leaving the European Union. So I'm not really sure if the points that you are making are relevant to this debate and this committee.
France?
Rather than...
Well, France are not leaving the EU.
France is not leaving the European Union, but this is an issue of internal security measures by way of precautions. We're not engaged in the broader policy issue of bilateral relations between Ireland and France in terms of advices or otherwise. That's not part of today's debate or discussion.
Well, I mean, you've actually contradicted your own argument there, Minister, because it's not long since a few minutes ago you told us that greater development of cooperation between the EU and third countries was going to be a big crucial factor of this. But I mean, Minister, do you not think that if this fund is going to be designed towards minimising the threat of terrorism, do you not think that there's merit in actually looking at the fact that as long as EU countries or third countries that you might be looking at to cooperate with, if these people are going to be involved in untold destruction in regions not far from the European borders, surely that's going to undermine the security of EU citizens. And is that not a concern for you?
Of course it's a concern. The security of the European Union and also in terms of our own domestic borders here is a matter of considerable concern. And this is an issue that the European Union is putting together an internal fund for disbursement throughout member states. We're opting in, and it's all about internal EU security and funding. We're not dealing with the overall foreign policy of other EU countries. However important that might be, it's not an issue for this debate this morning, or it's not an issue of concern in the matter of the putting together of this fund to safeguard and bolster the internal security of the European Union.
Okay, my last question, Minister. You're saying you don't want to be encroaching on foreign policy of other countries, although, I mean, it looks to me like this fund is going to bring them together a bit. But if you don't want to talk about them, how about talking about our own? I mean, has there been any discussion in relation to working towards greater security in Europe in general, including in Ireland? Have you considered putting an end to the US military use of Shannon in the interest of peace?
No, government has no plans in that regard.
Okay, thank you, Deputy Wallace. Look, in deference to everybody, it's just that we have a time frame for addressing this. I just ask members to please be cognizant of that. Deputy Jim O'Callaghan, please.
Thanks, Minister. I support opting in. I think it's important we recognise that there are threats to citizens within the European Union. They don't just come from terrorism, they come from organised crime as well. And I think, particularly with Brexit, that there needs to be increased cooperation between member states. And very many member states have had significant experience of terrorism and the damage it can cause, including our own country. So I don't think we can hide away from the fact that there are threats that exist there. The fund is 2.5 billion. 1.5 is going to go to member states. Each member state is going to get 5 million at the outset, and then there's a sum that will be calculated based on the domestic produce, population and territory. How much will Ireland get from that 1.5 million? 1.5 billion, I beg your pardon.
Yeah, it largely depends on the type of programmes that we will participate in. Initially, there will be €9 million in respect of €5 million in respect of the initial schemes. However, it's intended over the entire of the programme, assuming that Ireland will engage in the better information exchange, in the increased operational cooperation, that fund will rise over the period of the programme.
You said in your paper that each member state will receive a one-time fixed amount of €5 million, and then the rest will be calculated based on 45% in inverse proportion to the GDP, 40% in proportion to the size of the population, and 15% in proportion to the size of the territory. Now that is something that can be calculated very readily in respect of Ireland. I can't do it. Has your department done it?
It's initial 5 million. It's estimated that could rise certainly to 9 million and perhaps beyond.
Well, would you agree with me? We would hope that we would be getting more than 9 million out of a fund of 1.5 billion.
That will depend on the number of programmes involved. Initially, 5 million, and the likelihood being, as we engage in further programmes on the overall scheme, that will rise in the context of the 9. In the context of the 9 programmes.
The other 1 billion is going to a thematic facility. What is that thematic facility and where will it be based?
The level of programmes will actually be worked out between the Garda Síochána and the European Commission, and that's why we're very keen to have this matter addressed at the earliest opportunity. Opt in now. It will allow us participate in the initial €5 million portion, and then the further amounts in accordance with the breakdown. As far as the thematic arrangement is concerned, that will be in the organised through Brussels, primarily focused on emergency responses that the European Union will be faced with.
But when it says there's a new thematic facility that will get $1 billion, my understanding of that, and maybe I'm wrong, is that there's going to be some new permanent European base where this funding will be derived from. Like, is that going to be based in Brussels, or where is it going to be based?
Well, the disbursement and distribution of the funding will be through Brussels. However, it's too early to say that there will be a permanent operational office. But it's something that may well be considered in the context of the ongoing evolution of the programme.
Okay.
All right, Deputy. Thank you. Deputy Jack Chambers, please, followed by Deputy Clare Daly.
Thanks, Chair. Now, can you just give an outline of what's been the link in with PESCO on this, and what's been your department's correspondence, say, with the Department of Defence and some of the other departments around this, and just maybe can you fit it into that?
No, this will be a fund administered through the Garda Síochána.
Exclusively.
There will not be a mandate for the Department of Defence. We will continue to work closely with the Garda Síochána. The Garda Síochána will actually prepare the aspects of the programme for Ireland in conjunction with the European Commission. There isn't frontline involvement of the Department of Defence.
You mentioned Army in one of your responses, I'm not sure to who. So will it just be cooperation with a programme led by the Garda Síochána where the Army would have an involvement? Or
it will be.
Or what's been the discussions around that? I assume there will have to be PESCO cooperation with this programme at an EU level.
This programme will be exclusively led by Garda Síochána. Any involvement of military personnel or the Department of Defence will be in the context of current relations and discussions between Garda Síochána and the Department of Defence as far as emergency planning and otherwise is concerned.
Surely with a terrorist response you'd have to have cooperation, that's obvious.
There will be, but there will be not any designated funding within this programme for military personnel or the Department of Defence. This is exclusively the responsibility of the Garda Síochána.
Well, I read a report recently about this where is there anything around this decommissioning of some nuclear facilities? Is that part of this, and the safety aspects of that? Is that right? One of the programmes will be funding towards that.
I don't have any information on that.
And can you give examples of some of the other programmes that this thematic facility will provide for?
Well, there are 9 programmes being funded currently under 14 to 20. These would involve the sharing of information, the application of appropriate hardware domestically and across the European Union, and the appropriate software that will allow for the sharing of information and identification, for example, of passengers. Many of the schemes under EU PRUM are automatic fingerprinting, face recognition, working closely with Interpol and other agencies. For example, the rollout of what will be the passenger information exchange, the increased level of advanced security at airports, the facial recognition. All of these programmes, we're very keen that Ireland will play a full role in. And of course there are particular challenges for us from a security perspective in the context of Brexit. And we're keen therefore to be at the table early in order to ensure that we can participate in what would be best practice in the fight against terror, in the exchange, for example, of suspects' names, watch lists, all of which is required to be done at very short notice, and of course the availability of information as to identification and fingerprinting of those persons who would be coming into the state.
Just finally, would you support the establishment of a new agency, if that is what comes from this?
I'm very keen at Caoimhghín, having regard to the current international situation, having regard to the changing nature of organised crime and international terrorism, that Ireland fully participates in order to ensure that we're best placed to protect our people. Whether that involves the creation of new agencies or closer cooperation under current agencies is something that's under discussion as developments evolve.
And will you be putting in a bid like your other ministers for Ireland to be the capital of that agency, or is that too early?
Well, I'm always very keen to ensure that Ireland continues to play a leading role within the European Union, and also in terms of security and defence. Very conscious of our constitutional position here, anxious therefore to ensure that our people are safe and secure, and that we have the modern technological advances in order to facilitate that, and that we keep in close contact with our European colleagues. That will involve the expenditure of funding on a national basis in order to ensure that, for example, we fully participate in Schengen information systems, in the PRUM regulatory framework. And this particular fund, Chair, as I said at the outset, I'd be very keen that it would be favourably considered, having regard to the fact that Ireland will be a beneficiary of a multi-million euro budget, and anxious to ensure that we commence active engagement at the earliest opportunity.
Thank you, Tara. Thank you, Deputy Chambers. Deputy Clare, Daly, followed by Senator Niall O'Donnell.
Yeah, just briefly, Chair. I mean, look, I think there's actually a frightening lack of detail in the responses that have been given so far, and I suppose I'm wondering at this stage, given that we are under time pressure with other events today, and given the seriousness of this issue, what the big hurry is. The Minister made the point that he wants to be involved early to exercise influence. I'd question, I suppose, how much influence we're going to have, given that we're kind of a pittance in the big picture, as indicated from the financial figures that were mentioned earlier. So what's the big rush like? What's the problem? Why do we need to have this by tomorrow? Because presumably it's a choice we can join later on if we have a debate about it properly.
Well, I would have thought that you know, it was both logical and desirable that we would participate early. Many of these programmes are only being developed. If we're involved at the initial stage of the development of these programmes, well, then we can have our voice heard. We can exercise a level of influence. The preparatory work involved will be time-consuming, especially as there are a considerable number of proposals within the Justice and Home Affairs section, which are being pursued at the same time. The final language publication occurred last year, as far as the setting up is concerned. Accordingly, I was very keen early on in the session here that we would be in a position to participate. Oftentimes it's not possible to meet deadlines. We saw that last night in terms of the Seanad debate with Senator Donnnghaile. I always take the view, if we can get in early, we can help shape the architecture. I believe that's important. And I think in the overall context, we need to ensure that the Garda Síochána, as the delegated responsibility, authority under the current scheme that they're also fully prepared to embrace. What to my mind is a very positive initiative. So I would ask members to do what you said at the outset, Chair, that you would note it, but I would hope that at an early stage tomorrow or next week that the Houses of the Oireachtas could approve, and then as the programme is rolled out, can I say, Caoimhghín, that both myself and indeed the Garda Commissioner would be very happy to keep the committee informed of developments insofar as we can.
If I could just go back to the question that I actually asked. I mean, we know that you think it's logical and desirable that we would join early because you think that would enable us to have a greater influence. I'm not sure that that argument actually stands up to some serious scrutiny, given the size of Ireland vis-à-vis our European colleagues and their supposed expertise in relation to dealing with terrorism and the like. But what my question actually was, we know you are in a mad hurry for us to sign up to this by early, next week or something. It's on the Dáil schedule tomorrow, without debate. Given the fact that I am none the wiser based on the vagueness of some of the answers that colleagues have been given here today, what I'm asking is, what's the problem? Why does it need to be on the agenda without debate for tomorrow, and what's the consequences of that? Because I think the Parliament does need to discuss it.
Could I just codicil to that, Minister, maybe just for clarification, is it possible to revisit the without debate provision, and that there could be a time-framed opportunity for members to offer their views? Could you take those? I think they're the same question.
That'll be a matter for the Business Committee. I mean, the deadline for notifying the Council is the 2nd of October. That's next week. We were in recess. This is the second week back. I was in here last week. We could have arranged to take it last week, but you had a full schedule on that occasion. If the Business Committee decide to have a Dáil debate on this issue tomorrow, I'm available. But the deadline for a completion by us is the 2nd of October.
Yeah, what I'm asking is the deadline for what?
It wasn't possible to bring these motions during the summer recess.
Yeah.
And again, Chair, you and I had correspondence about the matter of the summer recess. Not that we want to revisit that, but accept the fact that
we know we're a very busy committee, and we know. What my question was, does the world cave in on the 2nd of October? Clearly, you can join after that. What I'm asking is...
No, but I already said, Caoimhghín, that it's my belief that joining afterwards...
Oh no, we heard all that. I'm
yeah.
just saying, but that's not my belief, so I'm just wondering, in weighing it up, what's the consequences, time-wise, of us not joining up on the 2nd of October? I know it would make you unhappy, but apart from that, what are the actual consequences?
Well, it's not that it would make me unhappy. The consequences would be that Ireland would not be participating at the shaping of these programmes, which I believe it's important, because when we're at the table, we can voice and amplify what is our own national interest here. And there's a particular issue as far as the relationship with third countries are concerned that we are very keen to elaborate upon, having regard to the imminent withdrawal of our nearest neighbour and closest partner, the UK, from the European Union.
Minister, but could I just clarify, just as a codicil again to Deputy Daly's question, is it the case that the shaping process, to call it what has been referred to, is to get underway as of or shortly after the 2nd of October?
Yes,
right.
These programmes are being rolled out. I believe it's important not only that we have a voice at the table early, but that we also join in a way that allows us enjoy a decision-making capacity and voting rights.
I hope if we're at the table we're a bit more clear than maybe we are today, but I mean, what I'm asking is that, okay, you want to be there on the 2nd of October, we heard that. Is there a barrier to you being there on the 17th of October? Can you say, listen, sorry about that now, but our Parliament actually wanted to discuss it, but we're sorted now, we're coming in on the 17th? Or is it you join by that, or you've lost your chance for a year? Is there something that says you can't go back in 2 weeks after that and say, okay, we're here now, we lost 2 weeks, but you look at what can you do?
I always believe it's important that we prepare. We want to be there for the adoption of the proposal at union level.
Yeah, no, I heard that bit, but is there an impediment to us going a week or two later, is the question?
Yes.
I don't think there is either. Well,
Yes, there is an impediment to us going a week
Okay,
later.
please,
Yes,
Minister,
yeah.
please elaborate.
That impediment will be that we mightn't enjoy voting rights at the adoption of resolutions.
What?
You know, I'm told on the one hand that I'm exaggerating our influence and that we don't have influence, and then I'm told that, you know, why bother even going to the initial stages of the drafting of the programme. You know, I don't subscribe to that. I believe it's important that Ireland takes its seat round the table, that we fully participate, that we have voting rights in the decision-making process, and that we can use our influence. You know, however weak and innocuous opposition members of our Parliament believe that influence to be, I believe it's far stronger than having an empty seat.
Yeah, just one point. I didn't say why bother. What I am concerned about is the backdrop to the views of the population in relation to the Lisbon Treaty, which this is an opt-in in relation to the Lisbon Treaty. But I'm also very cognizant of the fact that when we discuss internal security across Europe, we cannot divorce it from the decisions made by the European Union in relation to security, which has been very much raise the borders, spend massive amounts of money on surveillance and security, which is actually a mismanagement of funding as far as I'm concerned, and actually increases the likelihood of terrorism because of our interference in other regions in the world and so on. So I think they deserve some scrutiny, and really what I'm trying to find out is, can the House have that opportunity? I hear your point. I've every intention of raising it at the Business Committee tomorrow. If you're saying you're amenable to coming in and answering that, that's very helpful for the Business Committee. I'll let that be known to them, that you would make yourself available to facilitate that discussion. That will help the Business Committee, I'm sure. What I'm trying to get in doing that is, what would the consequences be of us delaying? And I haven't got any more clarity.
Oh, well, I can tell you the consequences would be adverse. It would mean that we would not be involved at the initial stages, we would not have voting rights, and it would be a signal from Ireland that we're less than committed to what most member states, including Ireland, have regarded as being a very welcome development in terms of the sharing of information, in terms of closer cooperation, and in terms of benefiting from a multi-million euro fund that the Garda Síochána could be actively engaged in formulating a programme for and on behalf of Ireland that will benefit our citizens and their security.
I won't say anything else, but I just don't buy that, because your argument has even shifted. A minute ago you're saying, oh, we mightn't get voting rights. Now you're saying in total, oh, we're not going to have voting rights?
I believe it's important, Chair, and I say this for the fifth time. I believe it's important that we participate at the earliest opportunity. Should the Houses of the Oireachtas decide otherwise, of course, that will be the position. But my proposal to the committee is that this is a welcome development for Ireland and for our security.
Thank you, Minister. Thank you, Deputy Daly. I'm sorry to Senator Donnghaile and to Deputy Brophy. I ask you just to be as brief as you can, in deference to our witnesses for the second session. Senator Donnghaile.
Okay, Carly, I'll be very brief. Minister, I share a lot of concerns expressed by Deputy Daly there in relation to the lack of clarity around some of this. But what struck me there, in terms of your advocating that you're there from the earliest possible stage in relation to the opt-out of third parties and third-party countries, and I might be completely going up the wrong path here, but it sounds to me like you want to be there to guard against some concerning positions that may be coming forward in relation to the impact on Ireland. So in expanding on that, Minister, it's just to ask, in terms of any opt-in with this, that you can give us a further reassurance that either through the Gardaí or indeed through cooperation with the Commission and broader European structures, that none of this is going to be directed towards or used for the enforcement or the hardening of policing along the border?
Mr. Please.
Well, what I will say is, Caoimhghín, having regard to the committee's remit of engaging on particular Garda programmes with An Garda Síochána, I would prefer if that issue was answered by An Garda Síochána for two reasons. Firstly, it would appear to be an operational matter. Secondly, it would appear to be an issue that would form part of a programme under this framework that will be designed by An Garda Síochána.
But very quickly, obviously from a government perspective, Minister, you have made very clear public commitments not to harden the border, that there will be no additional infrastructure, there will be no hardening of policing mechanics or anything else. So in terms of appreciating the operational status, and that's a question I of course will put to the Garda Commissioner, but from you as Minister and as a member of the Government, can you give a reassurance that any opt-in into this particular suggestion or this programme won't see resources from it, whether financial or other ways, directed towards that kind of policing along the border? What's your position on that and your department?
Well, I am fully satisfied, having regard to the public utterances of the British Government and in particular the British Prime Minister, that there will not be a hard border on the island of Ireland consequent on the withdrawal of the UK from the European Union. I'm not planning for such. The government is not planning for such. So I regard your question, therefore, as being one of little relevance, having regard to the fact that, as far as we are concerned, there will be no hard border on the island of Ireland. That's the view of the Irish Government, it's the view of the British Government, it's the view of the European Union.
It's very hopeful of you, Minister, but if there were, that's my concern. My concern is that you haven't articulated certainly the political position of your government, as stated numerous times here this morning, that there will be no hardening of the border, and that through the opt-in of this programme, you, or indeed the Gardaí, will ensure that as a result of our participation, whether it's pressure from domestically or indeed from the Commission, none of our involvement in this programme will result in enforcement or a hardening, or whatever way you want to put it, additional militarised, whatever it may be, policing infrastructure along the border.
No, there is no countenancing on the part of the Irish Government of the reintroduction of a hard border on the island of Ireland, north and south. So the application of any EU funding towards such an endeavour is not an issue.
Okay, Senator.
In deference to you, Chair, I will wait on the Commissioner comment.
I appreciate that. Deputy Colm Brophy, the last word in relation to this.
Yeah, thank you very much. Minister, I have to say, if I was sitting here this morning as someone who lived in Paris, or someone who lived in London, or someone who lived in numerous European cities which have been the victims of terrorism attacks in the last couple of years, if I was the parent of a child, or if it was someone, my partner or something like that, who'd been killed on a bridge or mown down and killed, I think I'd be at my wit's end listening to some of the most spurious stuff being wheeled out. My understanding of what you outlined this morning is, and I'd like you to just confirm this to me, that you're talking about a measure which European Union countries wish to enact to help fight terrorism. Now, I appreciate that some people have baggage from their history about fighting terrorism, but at the end of it, this is a measure which will enable the European Union to preserve the type of structures which we want to see, which is the ability for people to go out in the evening in their own city or their own country, is the ability of people to move from one EU member state to another, and to do that securely, and to ensure that the security services of the European Union act and coordinate together, and where possible act and coordinate with third countries to ensure that we don't have a situation, unfortunately, that we've seen so often in recent years. If that's the intent of this proposal, then I think it behoves us all to actually think of those people and work towards its speedy implementation. Thank you.
Minister, would you like to reply, please?
Well, just briefly, if I can say, by way of concluding remarks, unless there are further interventions, that the purpose of this proposal is to assist Member States of the European Union to intensify cooperation on a cross-border basis. And this is done in relation to ensuring that we are prepared for terrorist attacks, that we are engaged at a high level in the prevention of terrorist attacks, and that we are prepared for investigation, organised crime, terrorist attacks, ensuring that our people are protected. And I'm very keen that we would do this at the earliest opportunity in order that our voice be at the table and in order that we have our voting rights under Article 3. I think this is all about cooperation. It's all about ensuring that we can benefit from the European architecture in terms of information available, in terms of working together. This is a fund that the EU is making available for Member States. Ireland can be a beneficiary of this fund. And, you know, having regard, Chair, to the pressures on the public finance, and particularly in the area of Justice and Home Affairs, I would have thought that this would be seen as a welcome development by this committee. And I'm very keen that at the earliest opportunity, Ireland's voice is at the table, that the Gardaí can sit down with the EU Commission, work on the various programmes involved, that we keep the committee informed insofar as we can as to the nature and rollout of these programmes, all of which have the objective of protecting our citizens.
Good, Minister. No, Mick, I'm really sorry, but what I want to just say as Chair is that let everyone please note that, in my view, there is no lack of resolve on the part of any member of this committee or of these houses in facing the challenges of organised crime and international terrorism. I want to make that abundantly clear. And I'd like to also say, Minister, that it's absolutely right and proper that members tease out all of the elements of what has been put before us here today, because your own contribution, your opening remarks have been helpful, but we wouldn't have had sight of that in advance. I do say they were circulated earlier. Yes, of course, I accept
You didn't
that.
have sight of it.
No, we did. In fairness, no. But in terms of the time frame of having the opportunity to engage on this matter, this is the first that colleagues have had to do that. It's only right and proper, and I think that, you know, if it had been possible, members would be more informed, more across some of the elements and detail of it, and that would be to the benefit of an informed assessment. So, we'll leave it to the Business Committee to make its determination tomorrow as to how it progresses. I want to again thank the Minister for his attendance here today. A message will be sent to both houses of the Oireachtas that the Joint Committee on Justice and Equality has completed its consideration of this opt-in motion, and we shall suspend for 1 minute to facilitate the arrival of our next set of witnesses. Resume in public session, and the purpose of this second session of today's meeting of the Joint Oireachtas Committee on Justice and Equality is to resume our pre-legislative scrutiny of the general scheme of the 38th Amendment of the Constitution, the Role of Women Bill. For our second session today, we are joined by Ms. Justice Catherine McGuinness. You're most welcome. Dr. Helen Russell and Dr. Francis McGinnity of the Economic and Social Research Institute, both very welcome. Mr. John Dunn, Chief Executive, and Ms. Catherine Cox, Head of Communications of Family Carers Ireland, you're both very welcome. Miss Joan Canning and Miss Hilda Roach of the Irish Country Women's Association, Fáilte Roimh, and Miss Pauline O'Reilly of the Stay-at-Home Parents Association Ireland. You're very welcome, Pauline. And I'd like to also, some of you may have colleagues in the Visitors Gallery. You're also very welcome here this morning. So I shall invite you to make your opening statements in the order in which I've introduced you. I hope that that's okay. But before opening it up to members, to each of you, and to members to put questions to each of you subsequently, I am obliged to give you the privilege reminder. I have to draw your attention to the following. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable. And if I may also just to remind you, probably all have done it quite sensibly, to put your phones on silent, please, because if they go off, they interfere with the recording equipment in the committee rooms. So we'll get on with our business this morning, and I'd like to invite Miss Justice Catherine McGuinness to be the first of our contributors here this morning, if she will make her opening statement.
I first of all would like to apologise to the committee for the fact that my written submission arrived rather late. I was in fact staying in Connemara for some time, and unfortunately electronic communication from Connemara awaits the nationwide spread of broadband, which we all hope will occur shortly. And I'm greatly honoured to be asked to make a submission to this committee in connection with the scheme of arrangement for the 38th Amendment of the Constitution. And I'm not representing any particular group. I take it that I'm asked simply because I'm someone who has some knowledge of the Constitution and the law and experience over many years, dating, I think, from the time when there was an effort to try and remove the PR method of election many years ago, of the various attempts to change the Constitution that have occurred during my lifetime. As the committee knows, there have been many official and unofficial groups who have have criticised Article 41.2 of the Constitution and have sought either its deletion or its amendment to make it gender equal. And even at the time of the drafting of the Constitution, there was wide protests by individual women such as Hannah Sheehy Skeffington and leading individual Republican women about the idea of including this article, which pictured women's role as chiefly being as a wife and mother, as it were. However, I think it's necessary to look at the effect of the article over the years since its enactment, and you will have seen from my written submission that the understanding was that it affected discriminatory arrangements such as the marriage bar on employment, which lasted until 1973, and a genuine discriminatory attitude against women's employment outside the home. But we must ask ourselves, did the article and does the article actually provide a positive protection or a practical protection for the woman who did remain in her home and care for her children? And certainly it seems to me that this was not so in law and practice. And I had a personal involvement in the leading case, which I've described in my written submission, LVL, where the Supreme Court, while the High Court was willing to grant the woman a share in the family home, in ownership of the family home because of her role as a wife and mother, that was firmly rejected by every judge in the Supreme Court. We had 5 judgments pointing out that this was not the kind of role that could be taken by relying on that it was on the Constitution, that legislation was the way to go, and indeed legislation is the way that was gone in the subsequent to divorce legislation. So that I think among many groups, it's widely agreed that Article 41.2 is outdated, discriminatory and undesirable, at least in its present form. And should the question really before the Oireachtas is, should we try to amend that article, or should we simply delete it, or should we try to include fathers in it, and to include their place within the home and family? It seems to me that widening the section to include fathers has distinct difficulties. Obviously, I accept fully that fathers in this generation have a very much more, shall I say, hands-on and inclusive role in fatherhood and minding children than perhaps they did in my generation or the generation before me. But what then is to be done with it? Fair enough to include them in the first part of the article, but then what do you do with the second part of the article, which is basically saying that women should be protected from working outside the home? And that, in fact, is the part of the article that has been effective over the years in the marriage bar and so on. So what are we going to do? Say that fathers should be protected from working outside the home as well? I think that's somewhat impractical. On the other hand, if you drop part 2 and the first part is left alone, it seems to me that it's simply a kind of virtue-sounding, happy-sounding, vague sentiment of statement, rather than something that's really going to affect people's lives. On the other hand, people have asked that possibly the article should be amended to include a recognition of the work of carers in general. And again, as you've seen here, I've said that I certainly appreciate their vital role, and I appreciate the necessity for more support and more recognition to be given to carers of all sorts. But I think before embarking on doing that, we have to ask, what would the inclusion of carers in the Constitution, what would it really achieve? Or is it not legislation, practical legislation that we want? That, given that most assistance for carers are things that would involve public expenditure, and one doesn't readily achieve anything from statements in the Constitution that require public expenditure, they require legislation as well. So would a proposed inclusion achieve what is really needed, or would it be what I have rather wickedly described as simply a pious aspiration? Given that the most assistance for carers would really need public expenditure, decisions on public expenditure, the courts rightly regard that as the preserve of the Oireachtas and the government, that it's for the Oireachtas to decide these things, not for the courts. It's part of the division of powers. And so, again, there is the problem as to the definition of the word carers. I mean, we've seen this in the somewhat strange suggestion by Minister Ross that we should give €1,000 to every granny, and I mean, as a granny, of course, that would be just lovely. But such a suggestion falls down on the definition of the word granny, and equally, when you get to the definition of the word carer, which is a wide concept, you can get into I think there might be legal difficulties arising out of that subsequently, so that I think really however much we regard carers, we must look and see, before we embark on constitutional change, what we really want to get and how exactly we want to get it. So and how we would avoid unforeseen later difficulties and problems. I mean, as I've said, one is only to consider the history of the 8th Amendment, plus the proposed 12th Amendment, which didn't pass, the 13th Amendment, the 14th Amendment, and finally the need for repeal, to see what happens when you try to change the Constitution without being extremely careful about what exactly you're saying and what it actually means. Again, you all are aware that the provision for divorce in the Constitution was excessively detailed, which may have been needed at the time to get the referendum passed, but now we would love to be able to simplify and reform the divorce law, but in order to do so, we have to run a referendum and change the Constitution. So, I summarise that by saying the difficulty about framing a word to assist carers is that we can fall between the scylla of an anodyne aspiration and the charybdis of an over-complex attempted direction of the legislature that creates later problems. In summary, I think that the first task here, really, if we have decided we are moving to take away the Article 41(2), if we are going, let us delete it simpliciter. Let us just simply delete the article, and then, if it is the will and the intention of the Oireachtas to seek a referendum, to seek a change to benefit carers, or indeed to have a gender-balanced article, to start again, to rephrase it, to start to frame an article and think carefully with good advice as to what wording that you could have to avoid difficulties and to try to ensure that it would be effective. I think that's really all I have to say. Thank you.
Well, thank you very much indeed, Ms. Justice Catherine McGuinness, and we very much appreciate not only your written submission but your delivery on your views on that this morning. So we are now moving on to Dr. Helen Russell and Dr. Frances McGinnity of the Economic and Social Research Institute, in whichever order. Thank you.
Thank you. Yes, I'm going to speak, Chair. Let me begin by thanking the committee for the invitation to the ESRI to attend today. I'm Helen Russell and I'm Deputy Head of the Social Research Division at the Institute, and I'm joined by my colleague Frances McGinnity. Together we lead equality research at the Institute. The role of the ESRI is to provide an evidence base for policy rather than to advocate for a particular position, and it's in that capacity that we appear before the committee. In our submission, we present a number of ESRI studies which shed light on the changing gender roles and the distribution of paid and unpaid work and care in Ireland. The evidence shows that there's a clear mismatch between the role of women as framed in Article 41(2) of the Constitution and the reality of women's lives in the 21st century. It highlights the need to assess the impact of policy and legislation on gender inequalities both inside and outside the home and in both paid and unpaid work. It also reveals some of the complexities involved in defining unpaid work and care that may arise in the case of replacement wording for Article 41(2). So we focus in the submission on three issues. Firstly, how the role of women in Ireland in paid employment has changed. Secondly, the measurement and distribution of care and unpaid work. And thirdly, on the nature of policy support for combining employment and caring for young children. So first on the issue of women's changing position in the labour market, in a recent overview, we documented this change over 50 years. And we saw that starting from a very low base, women's employment increased gradually over the 1960s and 70s and 80s as a number of barriers were addressed, including things like the removal of the marriage bar and the introduction of equality and equal pay legislation. And women's educational qualifications over that period also increased. The pace of this change accelerated even further in the 1990s and 2000, which was a period which encompassed both significant policy development and an upsurge in demand for labour during the Celtic Tiger. And women responded to these changes with a rapid movement into the labour market. So the employment rate of women went from 36% in 1990 to 60% in 2016. But while the gender gap in employment rates narrowed, gender differences in pay and hours and conditions still persist. So, for example, 1/3 of women work part-time compared to 13% of men, and the gender pay gap has stuck at around 15%. So the increase in female employment has also been widespread, and it has included the mothers of young children. In the Growing Up in Ireland study, which we oversee at the ESRI, we find that just over half of mothers are in employment when their child turns 3, and almost 60% by the time the child is aged 5. Although OECD figures still show that the rate of employment amongst mothers of young children in Ireland is below the OECD average. So in summary, this evidence suggests that when afforded the opportunity and when barriers are removed, many women do enter employment. Those significant gender differences persist in the labour market. So turning to the issue of caring and unpaid work, what does our research say on this? So has there been a corresponding shift in men and women's involvement in unpaid work and caring? There's significantly less information on this side of the equation, and I think that reflects the lack of visibility and the undervaluing of care work. One of the first issues that we need to consider in doing research on this issue is how broadly unpaid work should be defined. From a gender equality perspective, the distribution of domestic work like cooking and housework is really important. And therefore, in our research and international research on this area, it would be included alongside caring work. Time use surveys are seen as a gold standard for trying to measure non-market work, and in Ireland we did. There's been just one national survey of this kind, and we carried it out at the ESRI in 2005 with support from the Department of Justice and Equality. And that showed the quantity of this unpaid work is very substantial indeed, and that its distribution is strongly gendered. On average, women spent just under 5 hours per day on unpaid work, while men did just under 2 hours per day. Within this, women spent an average of 2.5 hours on care per day, and men spent 39 minutes. And this includes both care for adults and children. Data from a European-wide survey allows for some comparison over time, and that showed that in 2016, 44% of women and 25% of men in Ireland were involved in care work on a daily basis. And that hadn't really changed from the time of the first European survey, which was 2003. It does suggest that there has been some change in the division of housework in Ireland, but the gender gap there remains wide. So to summarise, that research really highlights the scale of care and unpaid work, and the importance of making visible and valuing these activities from a gender equality perspective. One step towards highlighting unpaid work is to measure it, and by collecting time use surveys regularly, as is done in other countries. And this would allow, if it was wanted to be done, it would allow for an economic evaluation of care work. So turning to the final issue, which was we looked at in some of our research, was on the policy support for combining care and employment, and we focus on the care of children because that's where our own work has centred. Historically, there's been a very low level of state support for childcare in Ireland, and investment and policy development was in part curtailed by a political ambiguity about the merits of supporting mothers to enter employment. There has been an increased investment in childcare over the last decade, including the free preschool year and affordable childcare schemes, which represents a policy shift. Nevertheless, the burdens on families, the burden of costs remain high. Comparative research shows that we have in Ireland one of the highest childcare costs across the OECD. Our own study showed that parents were paying an average of 12% of their disposable household income on the care for one child at age 3. The study also clearly demonstrated that the amount that families pay for childcare affects how much paid employment mothers subsequently do, and that there was a reduction in the higher the costs, were associated with a subsequent reduction in women's paid work hours. A further finding of the study was the considerable involvement of relatives, particularly grandparents, in childcare in Ireland. At 3 years of age, among the children who were being looked after outside the home, 23% were being cared for by a relative. Now, some of that was paid and some was not paid. So 55% of it, there was no payment, and the rest there was a payment made. So I think that highlights some of the blurring of the boundaries of care inside and outside the home, and paid versus unpaid caring that might have to be grappled with alternative wording. Turning down very briefly to parental and maternity leave. So family leave is another part, another important element of supporting the combination of paid work and care for children. Provision takes the form of maternity leave, paternity and parental leave. The duration of maternity leave in Ireland compares reasonably well to other European countries, but the relatively low maximum payment means that the replacement rate falls below the rate found in a number of comparable EU countries. Parental leave has been extended, but it's unpaid. And so fathers' entitlement to paid leave is confined to 2 weeks paternity leave. So when you combine those supports and look at the amount and value of paid leave, Ireland falls in the lowest of 3 groups across 43 countries. So there's considerable scope there for improvement. The international evidence also suggests that where fathers take parental leave, this can lead to a greater sharing of unpaid work and care within the household, and that take-up for fathers is strongly related to payment. And in Ireland, we know that the take-up by fathers of the unpaid parental leave is low. So this evidence, to summarise, shows that combining work and caring of young children in Ireland remains challenging, and there's still significant gaps in support. So in conclusion, the research we've drawn on highlights very significant changes in gender roles in Ireland, but also the continued relevance of gender inequalities in both the public and private sphere. Care and unpaid work have been consistently undervalued, yet the scale of that endeavour is very substantial. The removal of the outdated gender stereotyping contained in Article 41.2 is an important symbolic move in terms of gender equality, a point which is recognised by a wide range of bodies. Our research does not speak directly to whether this should be replaced by another form of text. It does highlight a small part of the complexity that faces individuals and families in balancing paid work, housework and care needs, which change over people's lifetimes. It also presents some of the issues that are involved in defining care and non-market work, which are likely to arise in the framing and interpretation of alternative wording to the article. Our research also underlines the importance of a series of incremental legislative and policy changes that aim to remove barriers to women's entry to the labour market and to reduce gender inequalities in employment and resources. These reports remain necessary so that women can exercise their right to equal participation in public life, while at the same time contributions to care work are recognised and valued. Thank you very much.
Thank you, Dr. Russell, for a very informed presentation, and we thank the ESRI for their very detailed research in relation to this matter. It's most helpful. Thank you. I'm going on now to John and Catherine. John, you're the token man here today. You're very welcome.
Very brave of me.
You are, yes. So John is Chief Executive and Catherine Head of Communications. If one or other, or whatever way you've decided, I'll open the floor to you, please.
Thank you, Chairman. I'd like to thank you and the committee for the opportunity to present today on this important topic. Just a brief introduction. Family Carers Ireland is a national charity that for 26 years has worked to improve supports, services and recognition for anyone living with the challenges of caring for a family member or friend who is ill, frail, disabled or has mental health difficulties. We've over 4,000 members. We operate 20 care resource centres throughout the country and almost 100 community groups. We also provide in-home respite and home care throughout the country as an approved HSE provider. And this submission draws on our experience of supporting and advocating for Ireland's 355,000 active family carers, and that number, by the way, is a CSO figure, it's not our figure. On the issue of Article 41.2, Family Carers Ireland does not support repeal simpliciter. I'm very conscious, having listened to Justice McGuinness, that puts us, frankly, in direct opposition to her. And I want to acknowledge the arguments she made. And I want to say that in reaching our position, we do acknowledge those arguments, but we just have reached a different conclusion. And I'd like to explain perhaps why. We certainly have no issue with the overwhelming consensus that the article should be reworded to make it gender neutral. We also agree with the Human Rights Commission that the new wording should reference family life and that such reference should be understood as including a wide range of family relationships and include situations where families do not live in the same home. And finally, and for us most importantly, we believe that the replacement for Article 42 should make the recognition and support for unpaid care in the home that is implicit in the current wording explicit in the new wording. A lot of the discussion about this that I've heard so far has been in the context of the historical evolution of the Constitution and Irish society. I'd like to put it in a slightly different context, and that's the international context of today. Ireland is completely typical of every country in the world in that its health and social care system is predicated on complementary care and support provided through an extended family system. Ireland is, however, quite unusual in that it does not specify any constitutional framework around the respective roles of the state and the community in the provision of this care. Virtually every other country in the EU has some sort of legal basis where this is stated. It's not stated anywhere explicitly in Irish law or the Constitution. Family Carers Ireland believes that the overwhelming consensus in Ireland would support a constitutional provision that recognises the family's primary role in the provision of care and the state's self-interested responsibility to support families in performing this role, as well as acting as the provider of last resort where a family is unwilling or unable to perform the role properly. And there is survey evidence to suggest that that is the case. Our own overall preference will be based on the relevant provision, which is Article 67, I gave you a copy in the note, in the Portuguese Constitution, but we acknowledge that particular format wouldn't sit particularly comfortably within the structure of Donnchadh. Therefore, as the one that probably would fit best, we commend the wording proposed by the Constitution Review Group in 1996 to the Committee and the Government, and that is to delete Article 41.2 and replace it with the wording that the State recognises that family life gives to society a support without which the common good cannot be achieved, and the State shall endeavour to support persons caring for others within the home. We'd reject the suggestion that the second sentence be moved to Article 44.5, as we believe it's appropriate to frame the State's role as a duty of imperfect obligation, and I do take the point this is imperfect. If we were writing this Constitution purely from our own perspective, we'd simply say the State shall support. We recognise that's unrealistic. But on the other hand, moving it to Article 45 simply downgrades it to a guiding principle. And I don't mean to be smart when I say we were looking for something a bit stronger than that. I take the point that Justice McGuinness made that a lot of what we talk about in terms of supports involved expenditure, and that, in a sense, the constitutional provision, one way or the other, is going to be limited in that. But we don't believe it's anodyne to have an actual recognition of the role in the Constitution. We also believe that it happens to be in keeping with this government's own national carer strategy, which set out 3 principles in regard to carers, the first of which was recognition. And that is something that carers value very much. They find themselves battling constantly against the system for what they need. I'm not trying to make any points about that today, other than to say, at least within that battle, ongoing struggle, if they felt acknowledged and recognition for what they're doing, that is some consolation to them. The existing Article 41.2 has included the formula shall endeavour to support for 80 years. And indeed, as Justice McGuinness said, it hasn't really worked as a magnet for successful litigation or judicial subversion of the separation of powers. Indeed, in the event of a challenge under the proposed wording, it seems reasonable for the State to point out that it currently spends about $2.5 billion annually in its existing endeavours to support family carers through schemes that are defined in statute. We'd be critical of the adequacy and effectiveness of some of this expenditure, particularly the arbitrary pattern of its delivery in terms of a postcode lottery, and the fact that care in the home saves the State well in excess of $10 billion a year in return for the investment by the State. But I do struggle to see how any court might conclude that it doesn't represent a material endeavour in most circumstances. So we don't believe this is opening any enormous hole that the government finances are going to disappear down in. Others have already pointed out in this committee that judicial rights in the Constitution are not absolute. What I haven't heard in the consideration so far is the right, to point out that a right does not have to be enumerated in the Constitution to be guaranteed by it. So if the government is really worried about unknown risks, I venture to suggest that the risks are more controlled around a wording which includes a duty of imperfect obligation than around an absence of any wording, which would leave the Supreme Court potentially open to affirm any one or more unspecified and therefore potentially unqualified rights. Deletion simpliciter has been described as the pathway with the fewest risks and the safest way forward. We would argue, and this is what it would amount to, that deliberately and publicly repudiating the contribution of family care in the home constitutes a much greater risk to society and public policy in the medium term. Ireland faces a significant and rapidly growing demographic challenge. There has been a 36% increase in our older population over the past decade and a 63% in the number of people living with a disability over the same period. Currently, 1 in 10 people living in Ireland is providing some level of family care. With the demographic changes that we're expecting, this figure will have to have increased to 1 in 5 by 2030 if our existing policies and systems are to be sustainable. How will this happen without a clear social contract between the state and family carers? In recent years, it has not been unusual to hear leading government figures speak of building an Ireland which is the best place in the world in which to live, work and grow old. I think we would all agree with that. Where is the ambition hiding in talk of running away from unintended consequences in regard to modernising 41.2? Do we want to take the pathway of less risk or the right pathway? We should be thinking in terms of intended consequences, and these should be to recognise and support care in the home. Thank you.
Thank you very much indeed, John, and thank you to Family Carers Ireland. We're now going to move on to the Irish Country Women's Association, and I'd like again to welcome Ms Joan Canning, who is the President of the Dublin Federation, and Ms Hilda Roach, who is the President of the Wicklow Federation. You're both very welcome representing the Irish Country Women's Association. Joan, are you to lead off? Yes. Thank you very much.
Good morning, everyone. The ICA welcomes this opportunity to make this presentation and to contribute to the discussion on the proposed amendment to the Constitution addressing Article 41.2. On behalf of the National Executive Board, my colleague and I outlined the observations of the ICA in this matter. We hope this will assist the committee in its recommendations and in the most effective next steps to ensure that the Irish Constitution will be reflective of Irish society generally and of the role of women in Ireland in the 21st century. I'll deal with points 1 to 4. My colleague Hilda will deal with the remaining points. ICA is a well-known and respected organisation in Ireland and has had significant role since its foundation in 2010. In 1910. In more than a century, the association has vital support to women who gained personally, emotionally and vocationally in being of a community-based but nationally representative women's organisation. Our communities and our families benefited from personal development which we all experienced and from the association's attention to all aspects of women's lives. The ICA has been a lead voice in campaigning for change to benefit women individually as well as to enhance family life and that of the wider community. We are a founder member of the National Women's Council of Ireland and a member of the Associated Countrywomen of the World and active in both. It is with this background and track record that we make the following observations on the matter at hand, Article 41.2, and its focus on women's life in the home and duties in the home.
In the first instance, we support the position of the National Women's Council of Ireland that this matter warrants an active and wide-ranging debate with a focus on the intent of the wording in relation to care and nurture and how that intent can best be articulated in the 21st century. We believe that the wording in the Constitution has been interpreted in a narrow and restrictive way rather than facilitating a rights-based approach, ensuring that the value of nurture and care would be resourced, supported and valued. We take the view that as it stands, the wording confined women to the role of unpaid homemakers, although even back in the 1930s this hardly reflected the reality of many women's lives, whether in farming or family businesses or other work. Then, as now, thousands of women were also critical to the economic survival of families. The fact is that identifying women in their role in the home serve to provide the basis for discrimination such as the marriage ban and differential wage rates for women and men. We reject any intent or interpretation that fails to recognise women as equal citizens and contributors to our society. Today, we increasingly recognise the diverse roles of men and women within our families and intergenerationally. We also have a greater understanding of the shared and mutually enhancing roles of men and women in the caring responsibilities, whether of children or older relations, and in supporting healthy communities. At the level of the family, care responsibilities involve huge strain, and we have not managed to create the correct infrastructure or an appropriate way of thinking about these realities as equally important as economic sustainability and development. These are just a few observations that we believe are relevant to a debate which should focus on care and nurture as a social necessity and an essential good. We would hope that a national conversation would pose many questions and provide for a real opportunity to consider questions such as these. Does the Constitution require a statement which endorses and underpins the value of families and perhaps communities as central to support, care, nurture and the development of us all? What difference do we want to make and what is required to realise that difference? How do we reflect the importance of men and women in the intergenerational care contract? And is the Constitution the starting point? And do we need to be even more explicit about the equality of all citizens and the multiple roles that we all carry and have potential to achieve?
Well, thank you very much indeed, both Joan and Hilda, on behalf of the Irish Country Women's Association. And our final contributor, Pauline O'Reilly, on behalf of the Stay at Home Parents Association of Ireland. Pauline, please.
Thank you very much, Chair, and thank you to the committee for the invitation to speak here today. Being seen goes to the heart of what I'm going to talk about, so that recognition was really important to us. I suppose I should say that I was to have a colleague here today, and I think it's quite appropriate to say that she's with her 3 children because her husband couldn't take time off work for her to be here. So I'll just start with that. In quite an emotional way, I think, because this is emotional for us, when we go into the ballot box and as carers and as people who have been cared, and when we mark an X beside a yes or a no on that ballot paper, we're all attempting to assert our values. It's not a piece of legislation, it's something more visceral, and it's important to remember that the Constitution is a document that represents the people's voice, including carers. We also support the approach of the National Women's Council, and so today we're calling for an amendment to Article 41.2 that is compassionate, including a removal of the paternalistic and sexist language that we all agree is offensive here today, but the inclusion of a recognition that nurturing is important to who we are as a nation, and we mean this in the broadest possible sense of community. We would respectfully question the idea that deletion is simpler. Life is not always simple, and it exists in the margins of economic activity far too often, and we feel that this is a unique opportunity to express ourselves as a people. And if further examination is required to do this, then that's important work and can be done before any referendum takes place. So I'm going to touch first on the notion of equality, because this seems to have been key to the Minister's motion. We firmly believe that liberation of women is being conflated with economic activity for women, rather than looking at equality within the home and the workforce. There are many different I suppose measures that can be taken within the workforce as well as the home. Some may say that care work is something that holds us back as women, as a society, but in fact it's the lack of choice, the lack of financial support, the lack of recognition that really holds us back. Whether we work outside of the home full-time, part-time or not at all, caring still happens. The cared for still must be cared for by someone. We know that currently women carry out most of this work. We would like to see a more equal contribution from all genders and believe that only by elevating the status of care work that this can be achieved. So even within the paid workforce, women carry out the majority of care work, such as in creches, and these roles are amongst the lowest paid. And what we're asking here today is, who are we that we diminish the value of being with children and vulnerable adults and put every other work above that? When we voted yes on May 25th, we voted not only for the choice to end pregnancies, but also yes to support with the continuation of pregnancies for those who made this choice. Deleting care from the Constitution flies in the face of the commitment made to support all choices on the doors, including by me, although I'm speaking on my own behalf there. So some practical considerations then that we would feel that people should take on board when it comes to the referendum, and to put ourselves in the shoes of those going in there to vote. We don't want to pit ourselves against anyone, and often that can happen when we have people in different kind of circumstances in the home, outside of the home, and we're fearful that a referendum that offers deletion versus retention rather than amendment versus retention would do this. With tax individualisation in 2000 and a reduction in supports for lone parents who care at home, as well as a lack of increase for foster carers, we have experienced firsthand the erosion into the supports for families. And although Article 41.2 has never been challenged directly, certainly not at the Supreme Court level, as it stands, it could be argued that certain minimal supports such as child benefit and home carers tax credit could be dented more easily if it were removed without amendment. And this will weigh heavily on our members and other carers who rely on these and other supports when it comes time to vote, as they weigh up their commitment to gender equality, which most of us genuinely have, with the hard facts of looking out for our families' financial survival and our children's futures. Just a little bit about who we are then as an organisation. The Stay at Home Parents Association is relatively new, unlike some of the other organisations here. We were formed out of a common feeling of isolation and the lack of a voice. There are no trade unions for those engaged in unpaid work, nor could we afford to join unions, and there are no statutory bodies that have been established to support our work in the home, but we are a huge section of the population, past and present, who have made financial contributions to society and will do so again if supported. From the outset, we have been firm as an organisation in our belief that all families should be supported equally, whether engaged in paid or unpaid labour, whether headed by lone parents, married or cohabiting couples, including the LGBT+ community. We, as an organisation, are secular. We will take people from any religion and none, and we want to be recognised for our diversity as families in the broadest possible sense in an ever-changing society. So what is care then? Well, there's the physical and mental labour that it entails, but there's also the time away from paid employment that we can't ignore. It always means, always, providing for those that cannot earn an income, and therefore financially it is a very difficult position for most. You may have heard that more parents would choose to work outside of the home if childcare was affordable. And some would, but there are also many who cannot afford to stay home, and it is the lowest paid who actually return to work the fastest because they need the financial support. The fact that we need more choice in childcare is true, and it's a discussion for another day. We certainly believe that everybody should have all choices on the tables, but staying at home is almost never the cheaper option, and yet the majority, 62%, are the primary, are the sole, in fact, caregivers to their children, according to the CSO. Add to those all who are cared for, and those who care on a non-full-time basis, on maternity leave, parental leave, and every single waking moment outside of paid employment. As a society, we wouldn't be looking for these supports if being with family and community didn't matter to us. While we seek to put forward the position of parents, and that's my job here today, and guardians caring for children, we believe that the care of older persons and vulnerable adults is equally important, and many of us in this room will be in that position. We also want to recognise the valuable contribution socially and culturally that children and adults who are being cared for make to society, and this is often forgotten. We are carers for people because those people matter. In conclusion then, the reason that care work should be recognised in the Constitution as opposed to legislation is that governments who enact that legislation are often concerned with short-term economic activity, budget-to-budget kind of stuff, and the Constitution should assert higher values. Fundamentally, we want governments now and in the future to take note that paid labour market activation is not the only goal of our society. In fact, it's a means to an end for our society, not the goal at all. We want time with our families, whatever their shape and wherever we work. Thank you.
Thank you very much indeed, Pauline, and I think it would be appropriate if we also sent solidarity and good wishes to Catherine Walsh, who I hope is watching in as this meeting is taking place, and we hope the children are behaving. And I suppose, you know, it's only right and proper. There may well be members of the respective organisations represented here, and very particularly family carers and stay-at-home parents and those who are providing this essential support and service. We'd like to send them from this committee and this session here today our good wishes as well. So thank you very much indeed, one and all. I have a small number of indications. Now, before we go into members, what I'm proposing we don't do is when you pose a question that I seek 5 different answers. So I think it will be helpful. We want everyone to be a participant. But if you'd like to indicate maybe 2 to respond to any given question, and maybe to juggle it around a little bit, shuffle it, and we will get through our work in a reasonable time frame. Deputy Jim O'Callaghan, you're first. I know that Deputy Mick Wallace had indicated at the start, but he has a little bit of catching up to do because he's been on the floor.
Do you want to go first?
He's been on...
I'm sorry I had to go to the chamber for a question, so I'm really sorry about that.
He was holding a minister to account, as only he certainly can. So, Jim, you have the floor.
Yeah, thanks very much, Chairman. And I just want to start by thanking all of you for coming in this morning and for the reports that you've prepared. I know that I found them very helpful and been very useful to us, and it's also very encouraging that people attach such importance to the Constitution and really regard it as their document and are very concerned about how it should be changed or if it should be changed. Where we are as a committee, and I think where everyone here today is at present, everyone believes that the wording in Article 41(2) is inappropriate and it should go. And I suppose there are 3 options for us as a committee when we come to making a recommendation. 1, we just recommend deletion. 2, we recommend amending it, but not amending it in a meaningful way, just amending it to make it gender neutral and gender fairer. Or the 3rd option, that we would amend it in a meaningful way so that it would become a socio-economic right under the Constitution. And my own preliminary view, and I haven't reached a final view, is similar to Ms Justice McGuinness's view, that probably deletion is safer. But maybe I'm being overcautious about that. And if I could just ask you, Mrs Justice McGuinness, in terms of a proposed amendment to Article 41(2), would you agree with me that it is meaningless at present in terms of giving rights to women or even entitling a man to take a claim that he was discriminated because he's not mentioned there?
Yes, you see, you know, as I listened to the other people, of course it definitely makes me appear as kind of the nasty one that says, you know, just deletion and so on. But this is, of course, not based at all on the fact that I don't appreciate everything that carers and that men, fathers and mothers do and so on. I mean, I'm a mother myself and a grandmother, but I'm just listening to what the ESRI said, and you listen to the figures that they gave, and it seems to me that they provide a perfect illustration of the fact that the article has done no good at all to equality, to women or to families. I mean, they're really, that's the fact. So that I think that if we're thinking of creating a new article about carers, and I think most of us agree that it's a general carers we're talking about, not just making men come in along with women in the original article. If we're going to do this, I think we really do have to look at what effect it can have, given that the Constitution is not a policy document. It's a basic, I know it sets out values too, but it's a basic law, and you'd have to look and see. I mean, you ask me for, to say something, and you get a legal opinion, as it were, that you would have to envisage that if there was a challenge in court to whether the good things that were set out in the amendment were actually being done by the government, would the courts, or could the courts, grant what you have described as, you've rightly described as a socio-economic right, which the Irish courts have been remarkably reluctant to, certainly in recent years since Daly, as you will know, have been remarkably reluctant to grant socio-economic rights. So that I just think that I'm absolutely not. I'm not totally against you there. I'm not totally against putting in something that would show the value of caring, but please don't think it's going to mean that every government is going to leap into really doing something practical.
But would you agree with me, Ms. Justice McGuinness, that the right itself as it exists at present, it hasn't done anything for women? It hasn't given them any rights before the courts? Okay, it's purely...
That's clear from what's said by
but
the
it is a purely symbolic right.
Yes.
But in that case, are we being too overly cautious, maybe as lawyers or as a judge, about simply changing it so that it remains a symbolic right, but in fact it's broadened to include people other than women? Can that be done, do you think, if we just changed it in the way it was recommended by the Constitutional Convention, or by, as John and Catherine have suggested? Is that going? The courts are hardly going to reinterpret that differently.
Well, put it this way, I obviously couldn't be totally against that by any means. I just think a cleaner way of doing it would be to say, well, we take out the article that we have, and that we don't try to just mess around with its wording, and that we try to frame a broader article, sort of set out de novo, as it were, and to just not to think that it's going to achieve the devil and all, as it were. But certainly I don't think that there would be anything wrong in doing that.
Yeah, it's not too changed. Sorry, John, did you want to say something there?
No.
Yeah, sorry, I just wanted to say that we don't, in fact, quite explicitly in my remarks, we don't see this as creating any massive new socio-economic right. Or it is about the fact that I do think actually the Shall endeavour has delivered. If you look at policies, there are policies to support care in the home over the years. There may not have been much judicial review around it. I can assure you, if a provision goes in around Shall endeavour to support carers and we feel it's being neglected, we will take the opportunity to challenge that as an organisation. In doing that, we would recognise that it would be quite easy for the state to defend. So it would have to be something pretty egregious before we'd be using it. But that's not really, the main point of our argument is not about socio-economic rights, it's about recognition. And it's about the fact that, like it or lump it, that provision is in there. Take it out, it will be seen by people as a significant regressive step. So that's why we're saying, in a sense, put in something which isn't a whole lot stronger at all, but at least leave it in there as an acknowledgement of the value of care in the home.
So what you're advocating, John and Catherine, is that it should be changed, but that is not going to be changed in any meaningful way other than it will remain symbolic, but it will not simply apply to women. It will recognise the role of people. The formula
Shall endeavour stays exactly the same as it has been.
Catherine, sorry, did you want to say something?
I just want to say as well that, when we're talking about social and economic value, we have to remember that carers provide vital social and economic value to our society and in our community. With a saving of 10 billion every year. And as John said, we have put this to carers, and deletion to us is the greatest risk here, because you delete this, you take it out of the Constitution, you send a message that caring is not valued in the home. Now, whether that's an unintentional message, but that is the message that will be received.
Okay.
And there would be...
I suppose, and maybe if Joan, Hilda or Pauline want to comment in respect to this, I'll just set out what my concern about an amendment would be. And my concern is that we did change it significantly, and it was left to the courts then to interpret some new article. And when courts interpret rights from the Constitution, they do it on the basis of the people who take cases before them. I gave the example last week of an 18-year-old who collects his sister after school at 2:30 and minds her till the parents come home at 6:30. Like, what I wouldn't like to see is that some vague right put in, and that individual goes before the court and the judge says, yeah, you come within the definition of a carer in the home and you're entitled to be financially compensated and rewarded by the state. And then the state just deals with him. And it affects the whole social welfare policy and budget that the state affords to carers in general. So that's my fear in respect to it. And I don't think it's an irrational fear if we did go down the line of creating an absolutely new right. So I don't know whether Joan or Hilda or Pauline, I think you did advocate that maybe there should be a really strong right within the Constitution.
I think it was more that we felt, obviously, the gender, it has to be gender neutral.
Okay.
And also that the recognition would be given to carers.
Okay.
And I don't feel that we would be looking for something that was completely different. It's really to amend what we have there to make it more in keeping with the 21st century.
Yeah. Okay, that's very helpful. As I said, my view initially has been deletion, but I can understand the importance to people of having a constitutional provision there that recognises the symbolic role of carers. And maybe I'm looking at it too much as a cautious lawyer or something, concerned about what rights will be generated. And I'm sure it can be done that the wording could be amended so it wouldn't give rise to any new interpretation. Can I ask you just finally one other part? And I mentioned this to my colleagues yesterday. There's another provision in the Constitution, Article 45(4)(2). I just want to read out to you what it says. And it's in the social directive for the policies or the directives in respect to social policy. But it says, the state shall endeavour to ensure that the strength and health of workers, men and women, and the tender age of children shall not be abused, and that citizens shall not be forced by economic necessity to enter avocations unsuited to their sex, age or strength. Now, I'm not putting you on the spot here, but obviously it is perhaps similarly anachronistic, since it suggests that there are certain avocations, which are jobs, that people can't do because of their sex. I don't know if there's any that remain, but this was written in the 1930s, in fairness. But maybe if you got a chance, if you can't do it today, or to reflect on it, it could be amended by the deletion of the word sex, so that we'd still take account of age and strength. Yeah, certainly.
We would be against any, an amendment of 45.2
Okay.
instead. Look, it's been fairly clear, I think, from last week that it's non-justiciable, Article 45.2, and that's why. And I think it won't take much for us to actually hash that out in public to make that clear. I think deletion versus retention is much more dangerous, probably politically, than anything else, because you go into a ballot box and you have the two options there, and one is about care, and one, as I think I outlined there, is certainly removal of some child benefit has been spoken about a couple of times this year. It's very fresh in the minds of those who are care in the home, that removal of that article without putting something in there creates a fear for people. So we would have to then go in there and balance out how we feel about gender equality, which is it's a no-brainer, but how we feel about our families. Whereas if we're in there and we see retaining something that's clearly sexist versus amending it with something that values us, it's a no-brainer, So from a political perspective, I'd say that. And I'd also say that, I take the point that it's a legal document, and I have been a solicitor myself in the past, but I think that it also does have a non-legal basis, and we all recognise that, and it has a political, political decisions are made on the basis of what it says in the Constitution, and I think that that's only right.
Okay, thanks very much, everyone.
Are you happy enough with that,
Yeah.
Deputy O'Callaghan?
Yeah.
And we're doing this as we go along. So we saw how it worked with Jim, and if you'd like to, any of you to come in at any point, feel absolutely at your ease. The next to line up is Deputy Donnchadh Leary, to be followed by Senator Lorraine Clifford-Lee. Donnchadh.
First of all, I'd say I'm glad that we had these hearings. There was a bit of a discussion at some time ago that we should just proceed with the constitutional proposal as it was formulated by the government. I think that this hearing and the previous hearing has been valuable, because I think there is an interesting discussion to be had on this about whether it should be a simple deletion or whether there should be a replacement. I think there's been, I suppose I would be in a similar position to Jim, except on the opposite side of the equation, in that I hold an open mind, but that I generally am more inclined to replacing the current constitutional provision with something that is gender neutral and provides a meaningful recognition of the role of carers. Having said that, I retain an open mind in relation to it, and I suppose there's been these hearings as well, I think, are useful in just in terms of concentrating our minds as legislators on some of the legislative issues that need to be addressed in terms of supporting stay-at-home parents, in terms of maternity and paternity benefit and shared parental benefit and leave, and all sorts of other issues which I think need to be addressed. And like the Constitution is our basic law, and there is a statement of principles there too, but obviously the legislation needs to be there too. I suppose some of these, but obviously at the minute we are dealing with a proposal in relation to a constitutional question. I'm going to direct my questions, I suppose, primarily to Justice McGuinness, but perhaps some of the other speakers as we go along. But as with Jim, if there are people who, if there are any of the speakers or organisation want to offer a comment on any of the questions, that would be welcome too. Firstly, Justice McGuinness, and correct you if I can at all, I don't think anyone has come across that you're in any way nasty or anything like that, and I think everyone understands very much, like, I mean, this is a legal discussion, so I think everyone would appreciate the perspective from which you're coming. In relation to Article 41.2, and if the wording was to be along the lines of what was proposed by the Constitutional Review Group, I think, which was the point put forward by the family carers. Like, if you were a lawyer at this point in time and somebody came to you, can I take a case on the basis of that wording? Like, do you think that there is any obvious justiciable angle for anyone who wished to pursue a case?
Well, I don't really think there's any specific way in which you can deal with these things, because of the difficulty about taking cases on any of these articles really is that so many of them involve public expenditure, and it's clear in the basic laws, as it were, of the country, that public expenditure is the task of the Oireachtas and led by the government, and that courts are unlikely to order public expenditure unless in certain areas where there's an actual money owed to citizens, as for instance in the case when there were quite a large number of elderly persons in nursing homes who had been wrongly charged a fee for their care, and that question arose as a constitutional area which was dealt with by the Supreme Court, and the Supreme Court, unpopularly enough from the government point of view, ordered that all that money should be paid back to the elderly people who had been wrongfully charged, so that you can get that kind of decision. But I think that there is in fact a good case to be made, which has been made here, for making an overall statement which is supportive, and I would suggest of care in general, because care occurs in the family, outside the family, young people, of older people and so on, to set that out, I suppose, as a kind of ideal in the Constitution, a value, would certainly, you know, I wouldn't by any means entirely agree with it, but I just think that's a separate thing from fiddling about amending the article that's there now, and I think it's better to kind of say, well, let's get rid of this and put in what we really want. So that I think that's the simplest way of approaching it, but on the other hand, you know, I just don't see a case arising where you'd have someone who is a carer, perhaps, who was trying to establish a case. I mean, the way in which Deputy O'Callaghan set it out, I think, is actually what I would fear too, that you would get a kind of unbalanced thing. That there's, I mean, really, I think it's almost better to try and fight on the political legislative front for what we want. It's not that we don't want it, we do, but that to think that by putting it into the Constitution you are doing more than saying this is a value we hold, I think it's a mistake. Because, for instance, of course, once you start looking at Article 45, you find all sorts of splendid things that we should be concentrating on, but no one, but because it's not, you can't be fought in the courts, people don't take much notice of it. I mean, I'm sure that there's you know, a lot of I agree with you about the article that you just quoted, but whether we are willing to embark on a referendum to get rid of sex out of that is doubtful. No, it's just, we have to remember that what do we use the Constitution for? We should be using it, if we put in this, if we're going to put in about the care, you know, the value of care inside or outside the home, we should be using that as almost as a directive, as in Article 45, that it would be there to persuade the political parties and independents as they come up, that is the policy that they should be aiming for. And then we have to keep on fighting, I'm afraid, on the ground to get the actual legislation and the actual expenditure that's looked for.
I suppose just a few things on that. I suppose the difficulty with putting in Article 45 is, you know, similar enough to what you said. It may well be disregarded as all the other parts of Article 40 or Article 45 have been. I suppose just like what I'm trying to understand is, and I know this isn't the argument that you're putting forward, but so far as you can see, if the proposal adopted was a wording such as the Constitutional Review Group proposed, there's no obvious cause of action. Like, I mean, is that fair to say?
If I may say, when you're finished responding,
Yeah,
I'm going to go to the second Catherine. So we'll snap here.
Yes, yes.
So we'll let you come back first, if you, Justice McGuinness, please, if you wish.
No, I'm sorry, I didn't quite grasp the question.
If the alternative wording that was put in was the Constitutional Review Group proposal, or something in that general vein that made it gender neutral, there is no obvious, like, and there hasn't been much action or successful action on the basis of the current provision. There's no obvious cause of action from your point of view that could be taken. There's no obvious case that could be taken on the strength of it.
Yes, I think that's true. Well, but I mean, if people can always find a cause of action if they really are determined to do so, I don't think you can ever say there'll never be a cause of action. I don't know whether Deputy O'Callaghan would agree with me about that or not. But I mean, after I was certainly at the time when we took the L&L case under Article 41(2) and were making the argument in court that the woman should get half the family home, to own half the family home, because of what was said in Article 41(2) about the value of her work in the home, that it should mean actual money in the hand, well, possession in the hand, as it were. We were met with kind of well, a cold dismay, I think, by the Supreme Court that we should suggest that, although, of course, Judge Barr had given us half the family home in the High Court, but then that was overturned completely by the Supreme Court. So that I think that when you're trying to think of what would be a cause of action, it would be possible, of course, for someone to say in a case that it was stated in the Constitution that this, but you'd have to be sure that you are trying to claim something actual, concrete, something, some actual benefit, rather than, for instance, you can claim sort of in equal pay cases, for instance, you're establishing whether it's equal pay for equal work and that kind of thing. But if you're asking for, are we supporting carers properly, you can't make a sort of generalised claim. You'd have to find an actual plaintiff. And that, of course, would, if the Supreme Court is to decide whether the article would be effective or not, they would much prefer to do that on a specific case where they have a specific plaintiff. They don't really like kind of vague referrals, so that I just don't see that happening,
Okay. And Catherine Ella, please.
Just to go back to what Catherine said earlier, is it practical legislation that we need? I believe we need both. I believe we need to keep this in the Constitution, recognising, valuing the work of carers, and we do need, of course, we need practical legislation, and the government are currently drafting legislation on a statutory entitlement to home care, which will support that. But the other thing is, and the judge mentioned being very careful, give great consideration to what we're doing, get good advice. I believe all that to be the case, but we can still do that and keep it, amend it, and get all that advice before we amend. But rather than deletion now, deletes it and deletes the recognition that we have now.
Thank you, Catherine. Deputy O'Leary, are you okay with this? Or?
Yeah, I am.
Have you something further?
I have a further 2 questions, but unless anybody else wants to come in on the first one, I'm okay. I'll do it.
No, if you go ahead.
Yeah,
just in deference to everyone
Very
else.
good. Yeah. In relation to Article, sorry, I picked it up there from, I think, I may have misunderstood this, but just from John and Catherine, your presentation, like the view that if this was to be removed, that actually it's possible that some other element of the Constitution, I suppose presumably Article 40, could be found to, that could be the basis for, I'm trying to find now exactly the passage I was thinking of here, but like, it
doesn't have to be enumerated to be, yeah.
Do you believe, no, but I'm looking for the passage from the presentation, but do you believe that if this was to be deleted, that it would leave, first of all, a vacuum, but it's a vacuum that might be found or filled by a court at a later stage?
No, I don't believe it would leave a vacuum. I'm simply trying to argue or answer a concern which, frankly, I find a bit over the top, that changing this provision in the way that the Constitution Review Group suggested is going to lead to a floodgate of claims. We don't anticipate that. I said as much in my submission. Justice McGuinness is saying it as well. There is no conceivable way. There was a suggestion in that discussion which put at the end subject to legislation, but frankly I think that's redundant in the context of the way the Irish state works, the Constitution works, so I just don't think it's needed. We don't, I mean, the idea of somebody going in and saying, I collect my sister from school every day, I bring her home and I give her tea and biscuits when my mummy comes home from work and I want a carer's allowance, would be laughed out of court, and we'd be laughing with everybody else, because that would be a nonsense. And the state's answer is, we have limited resources, we concentrate them this way, this is not something we feel. I can't imagine any normal person in Ireland going with that. But can I give you a different scenario, which isn't a socio-economic right and is relevant to this committee? The assisted decision-making legislation, the capacity legislation, that will be commenced at some stage next year. On the day it's commenced, wards of court cease to exist. The state has given itself 3 years to work out the current wards of court into the new system. On the day it commences, every family carer in Ireland will be cast into a legal limbo until such time as they can register through the courts as an appointee under that system. We raised the point, we thought not unreasonably, that if the state was giving itself 3 years to do that, how about giving carers who have been caring maybe for 18 years already 3 years to do it as well? The answer we got was, no, that would be against the spirit of the legislation, because parents are wonderful, but we all know you can't trust them all. Now, there's a situation where you might well have a question about, are we really valuing care in the home if you're taking that attitude?
Yes, I see your point.
Deputy O'Leary, final question perhaps?
Yeah, final question. Just one more observation. Just, I suppose, in relation to the proposal, and I understand that, actually do understand the logic, but I suppose just the realities of this institution and democracy in Ireland, I would be hesitant in relation to a two-part process where we delete, and then we try and come up with a de novo process for coming up with a new proposal, because while I suppose it's accelerated in recent years, constitutional change, there's only so much bandwidth for referenda and for these institutions to process additional proposals. I suppose I would be of the view that there is no urgent rush with this. We'd like to get it expedited, but I would rather that if this debate was as comprehensive as possible and that there was some process following out from these committee hearings, that we can develop a comprehensive wording, or a wording that satisfies people. I would just be concerned that the second part of that process could be lost and could be, you move it and really you never get around to putting in anything on foot of it. I suppose my other question is, and I suppose I'm taking a slight liberty, it's tangentially related, but I would ask any of the speakers really, but Justice McGuinness, I suppose in particular, is Article 40, is there more room there for further rights to be found, or do we as a legislature need to do more to consider what social and economic rights, even aside from whether this would be justiciable, do we need to do more to consider further social and economic rights?
Well, if you went in for having social and economic rights enforceable through the Constitution, well, perhaps as things are at the moment, you might consider having a right to housing.
I agree with that.
You look at it, you need to look at the way other constitutions in other jurisdictions work, where there are, for instance, the Constitution of South Africa, in which Mr. Kader Asmal, who was long here in Ireland, played a big part in drafting, and obviously he would have had experience of the Irish Constitution as he lectured in Trinity on law. I was in fact a student of his at one time, but they have put in a right to housing in the Constitution, and it was to an extent enforceable in that the Supreme Court in South Africa directed certain ways in which the money that was to be given to housing by the government was, in certain ways in which it was to be divided, as it were. And there was, to a degree, an enforcement of a socio-economic right like that. But that's, we are used to what's called the common law system, as I'm sure you know, which is basically in Britain and in ourselves and in many countries which were formerly British colonies, like Australia and Canada and so on. And generally speaking, Canada would be the nearest to having a constitution that would enforce certain socio-economic rights, Canada and South Africa, and it has to an extent been effective, so that provided one had a Supreme Court that was willing to move in that direction, something like that might be achieved. But what would concern me at present is the division of powers is such that the Supreme Court itself will decide whether it's going to enforce socio-economic rights. It's not for us to decide that, and generally speaking, we haven't done that. And it is difficult, because to try to embark on that means that you're directing the government how they spend the taxpayers' money. And you know, the taxpayer themselves mightn't be all that appreciative of the idea of a set of lawyers sitting up there who haven't, as it were, skin in the game to direct how taxpayers' money is going to be spent. The tradition is that that's for you people responsible, which is a very responsible task, and one that takes a great deal of thought on. You know yourselves how much difficulty it is. But of course, you could always look at, there's parts of Article 45 that might inspire you if you wanted directions in which to go. Just as I was going through the Constitution there when you raised the question, I was looking at Article 45(2), that the ownership and control of the material resources of the community may be so distributed amongst private individuals and the various classes as best to subserve the common good. I think that a little thought on that might, in a country where it appears that the difference between the wealthy and the poor is growing, might give rise to some thought. But, I mean, now that's nothing to do with what I was supposed to be talking about. I'm just being evil.
But you used the opportunity well.
I just used it.
And Deputy O'Leary has noted it very well, too.
That's what I was hoping for, yeah.
Catherine Cox, please.
Yes.
In the Constitution at the moment, we do have a right to primary education, which does look at positive socio and economic rights, and that has served as well in terms that it has been used reasonably and appropriately. So there is precedence there for something like this. So again, we shouldn't, run from those risks, but examine them.
Thank you, Deputy O'Leary. On to Senator Lorraine Clifford-Lee, please.
Thank you very much, Caoimhghín, and apologies for missing the first half of this session. I was in the chamber talking on the matter, and the contributions that I did hear were excellent, so thank you very much for that, and I've read other contributions, so thank you. I was very happy to hear that the approach that you're taking is not to kind of pitch different groups of women against each other, because I strongly believe the only way that we're going to achieve real equality is by working together for our common good and the elevation of all women in Irish society and in the world. So I was very glad to hear that. Just a kind of a brief comment, if I could, at the start before posing some questions in relation to the cleaner approach being the deletion of the article. You could say that about every article in the Constitution. It would be a lot cleaner for everybody if most of them didn't exist. So I don't really see that as a basis on which we should proceed. And I'm coming to this with an open mind, and I'm listening to the contributions. I'm going to weigh them up and discuss them with my colleagues and decide our approach there. But I suppose my question would be to any of you and all of you would be whether, if we change the language within the article to gender-neutral language and remove the economic element of it also, which would kind of serve the purposes of recognising the value of care, and this would then remove the public expenditure element, I suppose, that the point that we're kind of afraid of, creating economic rights and taking that public expenditure role away from the Oireachtas, whether that would be enough to elevate the status of care do you get what I mean on that? And if we're just going to have this article as a persuasive point and something for us to use, or something for you to use to lobby us and us to use to lobby the government, then would that be enough? Just neutralising it in terms of gender, taking out the economic element, and having this debate here in the Oireachtas and having it on the airwaves and during the course of the campaign and actually discussing care. Would that be enough?
Is that directed?
Yeah. Well, anybody?
Sure.
Yeah.
I mean, I think it's very hard to say.
I'm supposed to answer that, but
Catherine, you're not getting the first bite at it this time, but we're going to bring you in a moment. And Pauline has taken up the cudgels.
Yeah, I mean, you know, if you ask any of us, we're going to say that we would like it to be shall rather than endeavour. You know, that's the reality. But I think until I would see it much like what the National Women's Council said, that it would be a proper debate, a deliberative process that would involve civil society groups, not something that's on the airwaves, because I really genuinely don't want to go down that route. I have worked outside and inside the home, and I don't want this to just become a media frenzy. I think that we have to look at all of those issues, and it should be a deliberative process. So I think it should be a citizens' assembly to work out the actual wording rather than us work it out here this morning.
But do you think if your organisation would be happy with the removal of the economic element, if we're talking about keeping it in the Constitution rather than deletion of it?
We haven't taken a position on that, so I don't want to. I suppose I don't want to. Say one way or the other. I think that it should be a broader discussion over a longer period of time. We weren't quite expecting that. For instance, there would be no pre-legislative scrutiny at all, so we were taking a longer view on it, and that's what we'd like to do now. Thank you.
Lorraine, would family carers like to just reflect on that point, because it is an interesting...
It is, and what we've said is that we would support, the state shall endeavour to support persons caring. Having said that, we would far prefer to see the state shall support, but we are willing, I suppose, to be reasonable and say that if the state could give a commitment to endeavour to support, at least that's bringing it further than. So we're not saying to remove the support element. We want to keep that in there. We want recognition, but we want support as well. But we're willing to take the endeavour to.
Could I give?
Yes, John.
Could I give a practical example? In order to qualify for carers allowance social welfare payment, which is only slightly above unemployment benefit, frankly, carers are required to demonstrate that they are providing 40 hours a week consistently of care for a medically diagnosed condition. Now, you could argue that under this constitution, under the proposed provision, we could charge in and say, no, you only have to be given 5 minutes care. Happy to put it on the record now, that wouldn't be where we'd be coming from, and I would assume any state would say, certainly in the context of shall endeavour, that that's an unreasonable claim, and actually it is. Now, you could argue that the 40 could come down to maybe the average working week rather than more, but in principle, of course the state has the right to regulate how it's going to manage its finite resources. It has to have. I mean, there's no question about that. But this is as much about the symbolism of taking something out of the Constitution. If it wasn't in the Constitution at all, we'd be having a very different debate about whether or not it's worth putting it in. Yeah. Our biggest concern is if you take it out, what sort of message are you sending?
Further response, Senator Hilda, on behalf of the ICA, please.
Yes, I think we would be of like mind that I agree with what Deputy O'Leary said. The debate needs to be as comprehensive as possible so that we can come up with a workable new wording. And I think on the two, the state shall endeavour to ensure that carers, I think we would also be happy, satisfied with that.
And maybe just as the initial focus might have been on yourself. Catherine, have you a further word on this before we go back to the Senator? Would you like to add anything at all on what's been said?
I don't know that I should be adding anything here. I certainly take the points that's being made here, that I think that about the removal of one and leaving nothing else instead. I think that is a point that the Oireachtas will really have to consider very carefully, because it does seem to me to be a valid point. I think, as regards what Senator O'Leary said, that I don't think you can phrase the thing in such a way that it might imply that the state should be giving some financial support without actually making it so directive that that it would be going outside the usual constitutional framework. I mean, lots of things in the Constitution imply expenditure, such as the article that says the providing for education. Though, mind you, you have to bear in mind the difference between providing education and providing for education, which has been very much a constitutional question. But, you know, the wording could be adjusted in such a way that it wouldn't be outside normal framework of constitutional wording. But it would. I don't think you have to be too scared about implying that the state would have to spend some money.
Thank you very much for that.
Clifford-Lee, have you anything further you'd like to ask?
No, that's great. That was one kind of question that I was quite eager to pose, so I appreciate all the responses.
Thank you very much indeed. Thank you. Deputy Clare Daly, please.
Okay, thanks, Chair, and thanks very much to everybody for coming in. It's been really excellent, actually, and you know, we made the point last week that the requirement for pre-leg has been so well demonstrated by the contributors who've come before us both today and indeed last week, that it's been incredibly helpful. And in that sense, I don't have a huge amount of questions, because I thought you were very strong, and thankfully most people were of a view similar to my own, that it should be a replacement. But how do we get to that replacement, I suppose, is the meat in the sandwich that we need to tease out a little bit. So just maybe a couple of things on it. I think the first thing that strikes me is what people seem to be saying is that this can be, and to me it already has been, a very important sort of values clarification process for Irish society at a juncture when we're maybe evaluating, I suppose, a new Ireland or a lot of new family life and so on. And in that sense, it can be quite empowering. The government have put forward a two-tier strategy. They recognise that we need to move from the past, but they're saying we'll take it out and then we'll discuss the future. I think what people are saying, by even doing that, you're downgrading the role of care and unpaid work, and that is putting a value and a bad value on the thing. But just that two-stage process, if people want to tease that out a bit, it's a little bit, maybe ties in with a point Jim made, and he probably didn't mean it like this, but he talked about a symbolic provision rather than a meaningful one. What I'm hearing from people is that actually symbolism is meaningful. It's not enough, but symbolism is not nothing either. So maybe if people want to tease that out. I suppose what I mainly want to know is that if we're all kind of agreed that something should go in, the idea of a process being engaged in quickly, could you see yourselves, I suppose, facilitating a citizens' assembly type mechanism if it was established now, with a view to what has been spoken about, or do people feel this is too early? What was being spoken about was a referendum maybe next summer to tie in with the local and European elections. Do you think that there's enough time to provide for that? I suppose that's one practical question. I have a question for the ESRI regarding the 05 report. That, I think you said that was the only evaluation of unpaid work, which is quite incredible. And is there any indication of that? Because to me, what really came, and it's a comment really rather than a question, but you all made the point so powerfully that you kind of robbed us of any decent questions, is that we're valuing only economic activity, paid economic activity. The unpaid activity has a value, and a huge value, but it's not given its place. And I suppose what we have a chance to do that. So on where we're going on that? Is there any more research? But also maybe John's point, I think you said something that we're kind of unique in not recognising that care role. If you could maybe explain that, because the Minister would have kind of put that differently, kind of saying if we put it in, we'd be unique in doing it. They're kind of the opposite point, you know. But I thought you really, all of you actually highlighted so well about what we want as a society, like in terms of values and the role of care work and putting it on a parallel footing. So I'd be confident, based on what you've given us so far, that we could meet the 6-month deadline to next year, but I'd be curious as to what other people thought of that, you know.
Well, there were a number of questions and they're not in any particular order. So what applies to you, and each of you in your own turn. John, you were first to indicate.
Well, it was just my microphone was on, it looked like. I'd say the two-stage process, I would be completely opposed to a two-stage process. We've lived with this wording for 80 years. We can live with it for another 1 or 2 to get it right. But I would events, dear boy, if we do a repeal simpliciter and then sit down to talk about what we're going to put in, that's just not credible to me. I couldn't have put it better. It's lots of negatives, but I use that myself. Symbolism is not nothing. That's the key message we're trying to put across. Could the process be dealt with quickly? Well, frankly, I'm less exercised about it coinciding with the timing. I'd like us to get it right. I think the Constitution, that's the way you should approach it. I've heard other people say it's ambitious, but it could be done. My experience is these things usually take a bit longer if you're trying to bring people along and build a consensus. So rather than fixing a time frame and then finding you're running out of time, I'd simply say let it run until. There is another piece of research on unpaid work, and that is the health survey that the CSO did in 2016, 2015. That rather blew our socks off, because they came up, now it was a sample study, but it was a very detailed study of activity, and what they said was that 355,000 people in Ireland were providing about 40 hours a week, a minimum of 40 hours a week, unpaid care. So that's a really interesting piece. Now it's the first of that kind of study. We're looking forward to seeing the second one. It's a sample, it's a good sample, so it should be reasonably reliable, but you'd want to see a bit of a trend before you banked on it.
Is there another one due, do you know? Or?
I don't know.
Yeah, I don't think so in the short term.
And then the international uniqueness, you asked me about that. I mean, there is a typology they've developed in the European Union. So the Scandinavians would tend to put the primary responsibility on the state. And the downside to that is you wander in and you say, I'm worried about my mother, and they say, well, go away, we're looking after her. I don't think there'd be much appetite for that in Ireland. Now, that's a bit of a caricature, but still. Then, within the rest of Europe, it's primarily that the state relies on and recognises the role of the family. You've got the German kind of system, which is driven by a compulsory insurance, so you pay for your care in your old age, and if you haven't got any children, would you believe you pay a higher premium because they recognise that there's going to be no one to help looking after you. So there's a logic to that. In Estonia, it's written into the constitution that the family is the primary responsibility for antecedents, so basically your parents. And as a result, the state there, it's just begun to very much relax this a tiny bit now, but up to now it's said it's family's responsibility, we have nothing to do with it. So if you have living children or other kind of offspring or relations, they'll do nothing. They'll only look after you if you're completely isolated. And then the other side of the coin, you have the Portuguese system, where it is the state recognises it depends on families for doing things. Now I say families caring, whatever word you want to put in there. And we recognise that it's in our interest to actually help you do it, because the state would fall over without it. 80% at least of the care in Ireland is delivered by unpaid. And in terms of the confusion about unpaid, someone who's getting a carer's allowance, that is in lieu of, if you want to put it that way, unemployment benefit. And we made the point to social welfare some years ago and they accepted it. It is absolutely not in the state's interest to start trying to force carers out of the home to take up paid employment, simply because they'd have to backfill with paid services. So the paid for bit to us doesn't include carers allowance, but carers sometimes get a bit confused about that because they say, I'm getting money from the state. For us, paid work is performed by healthcare or by home care workers, and carers in the home, family carers, are unpaid, whether or not they're getting assistance from the state. But the international bit, I can send you some information on it. There's 5 models, 5 systems, but we are unusual in that nowhere in legislation or in the Constitution does it clearly say what are the respective roles of the state and the family. And we think, our argument is it's partnership, and we think that needs to be captured somewhere as a fundamental statement, and as a fundamental, we put it into the Constitution.
Frances, please.
Yes, in response to that point about the time use survey being in 2005, it's fair to say that paid work is measured on a regular basis in Ireland, quarterly, but actually care and unpaid housework is much less commonly measured, and this is one step towards valuing it, is actually to measure it, notwithstanding the caring survey. If you want to measure housework and caring and the different kind of caring activities, other countries have regular time use surveys where people fill out diaries of what they do each day, which is what we did in 2005. And the idea was at that point that there would be a large survey. I think the intention was that there would be time use surveys, that caring and housework would be measured on a regular basis. But I guess then partly the recession came and everything stopped. But there is a strong argument, no intention that we know of, but there is a strong argument for having a regular measurement of time use surveys that would complement surveys of caring by the Central Statistics Office.
Thank you very much, Frances. Anybody else would like to pick up on Deputy Daly's points? Pauline?
Make a point around I suppose, this whole idea of supporting unpaid work, that I think that we are moving, more generally, we are moving to a stage where employment or labour is automated, but caring work will never be automated. You're never going to have a conveyor belt for older persons, for vulnerable adults, and we've seen that those numbers are increasing, or for children, and nor should we. And so we are going to have to think in different ways about how we support all of the valuable work from actually what is maybe a smaller pot of those who are getting paid for their work. So that's a more general comment.
Thank you for that. Deputy Daly, I'll come back to you now.
No, that's
You're
very
happy?
good. Yeah, no, it's
Very
been
good.
excellent, really.
I noted what you said in relation to the contributions and that you felt robbed of questions. I was thinking for a moment that the first session this morning had the Minister where you're all seated. He would have loved that to come from Deputy Daly, I want to tell you. And it didn't happen for him. Deputy Chambers, please.
Thanks, Chair. And first of all, I want to apologise. I wasn't here for a lot of your contributions. I was with a thalidomide group outside, and so I'll read back a lot of your submissions. But just a couple of questions from the interaction I've heard so far. I suppose, I came into this thinking deletion was the right thing, and I'm open to, reading the submissions you make and the arguments that are made as well. Just first of all, the politics of this. If there was a proposal to delete this proposal, or the current constitutional provision, would have your groups made a decision if you'd oppose that on the basis you want a further, just to be clear about that? And I suppose, I don't know if you want to maybe elaborate on that a little bit, maybe each of the groups, just so we know very clearly what the position is. That may have been mentioned so far, but yeah.
Have to identify between the two of you to lead.
Very strongly, family carers on the ground would absolutely oppose it.
Yeah.
And as I said, would feel bitterly disappointed, but anger as well. So definitely there would be huge opposition to deletion.
Okay. And even if the government...
Did you want to go round to each of the groups?
Yeah,
I thought you did.
People, yeah, absolutely.
I thought you did. Pauline, would you like to offer just...
We have asked which of the three options, and the amendment came back, by almost all. And I suppose when I say amendment, I think maybe it's more correct, having heard Justice McGuinness, to say replacement, so that we're not talking about food thrown around the words. We're actually talking about taking something out and putting something in, but in the one go.
Okay.
So we haven't asked, and again, it's not my place here, I suppose, to guess at what the general population who are inside and outside, but we know that those who have cared for children are you know, they're not just my generation, they're older and younger generations. Those who have been cared for are a lot of people probably in this room, and so it goes beyond actually our members in many ways, so we'll all have to guess at it. I think I've laid out, and possibly Deputy, we're outside of the room, that if you go in, it's a very visceral experience. You're being asked to weigh up your values, and the two values are important.
Yeah,
so,
I know, fair enough.
And maybe just to, you know, from Helen and Joan and Hilda from ICA, would you like to offer a view?
Similarly, it's not something that we have discussed as regards if it was just to delete. We would see that not having a replacement would be a wasted opportunity, and we would be very much in favour of coming up with a workable new wording.
That's helpful.
So I like to add, I mean, maybe not within your domain, not within your domain. And I can see Catherine out there campaigning somewhere.
A bit old for the street campaign.
Not at all, Catherine. No.
But and say the I suppose when we had the minister in, he mentioned a process of, say, a citizens' assembly post the referendum, and any of us who are at this committee know that, you know, promises post anything are often take a long time. So even if that was the commitment, you'd still maintain the grounds that it should be replaced. Okay.
Absolutely.
And just to go back, I know Jim mentioned, and you came in on that, say some examples of how you would regulate or provide a framework around a constitutional right, and whether it's symbolic or meaningful, and how you structure that. Can you give an example of what kind of case you would envisage coming before the courts, that where you would have a meaningful, you know, a meaningful exercise of that right, and just so we can maybe one or two examples of what you would see as the positive constitutional change delivering for people who are carers today.
The first thing I'd say is I wouldn't necessarily rely on the article for the kind of cases we might consider bringing.
No, I would say there was a replacement article.
Yeah, well, no, I mean the replacement article. Yeah. I mean, the one thing I wouldn't see happening, as I said, was you know, the person who's collecting their sister from school and bringing them home and looking after them for 2 hours, because the obvious answer from the state for that is we have a scheme which provides for, and the person doesn't qualify under the criteria, and I think the Supreme Court would accept that.
But how does the state regulate a constitutional right?
Because it's the balance is there, shall endeavour. The shall creates an obligation. Endeavour creates a qualified obligation, and therefore the only thing you can do in that situation is bring it to the courts to have a light shone on it. And 9 times out of 10, certainly in terms of socio-economic rights, the state will easily assert that it is endeavouring, even if it isn't succeeding, it's endeavouring. So to me, it's a weak obligation. But it's, I mean, when I was studying the Constitution, and my interest is administrative law rather than the rights end of it, but as far as I was concerned, the Constitution stopped at Article 44. Like 45 was a nice little PS. It wasn't really part of it at all. So from that point of view, we do think it should be in the Constitution proper. And I mean, as somebody already said, the ultimate logic of the alternative position is why don't we delete all the human rights, because they're all very messy and awkward anyhow. So would you have any examples of a kind of, I suppose I take your point that shall endeavour means it's a qualified. Well, an example I gave was that under the assisted decision-making legislation, if the state wants to turn around and put thousands of parents and carers into a legal limbo on the basis that, I don't know exactly what the basis is, I'd consider challenging that, and I would challenge it on the basis it is clearly unfair and unreasonable. If there was a modified Article 41(2) there, I might also say, and it also undermines care in the home. We have situations where someone will go into a home and say, oh, this is a big man in a bed who needs 2 people to work a hoist, and we don't have the budget for that, and go away again. Now, there may well be a grounds there where the principle is already accepted that we provide care in the home, but actually if it's too difficult to provide the care we don't, I think that might be a grounds where you could be. But these are very unusual ones. They're not typical, and it's certainly not about socio-economic rights.
Yeah. No, and thanks again for your contribution. I know
thank you, Deputy
and just to say I think the timeline around the capacity legislation, I think even what you believe it might be is ambitious based on the officials who came before us earlier on this year. It seems to be delayed again, which isn't which is worrying and concerning for us all. But
well, it is a little bit, but the point I was making is the state, as it tends to do, made generous provision for itself and then threw everyone else to the wolves, kind of.
Well, the delays are a disgrace on that side of it as well. But thanks again.
Thank you. Deputy Mick Wallace, our last contributor.
Thanks, Caoimhghín. And I'm sorry for the parts I missed. I'll read the contributions to catch up. I'm not even going to ask these questions. Just thanks very much. And Hilda was talking about a wasted opportunity if we didn't do something and put something back in. But your contributions have highlighted that it would have been a terrible wasted opportunity if we didn't even have pre-leg and we had just let this run over and ended up with a referendum on, say, 26th of October without any discussion or understanding of what was really at stake. So thanks very much, and hopefully we've all a lot to learn still, but if we don't listen, we won't learn. And I think a discussion in an assembly of sorts is going to have a lot to offer. Thanks.
Thank you very much, Deputy Wallace. Just before I do the little roundup, was there anything that any of you would like to just add to what you've already presented to us this morning? You've just offered us an opportunity. Are we all okay? We're happy we've communicated what we came to say. I have no doubt that you have, but I just said I would offer it in any event. So I just like to say that you know, the process. No, it's fair to reflect. The decision that the committee took to do pre-legislative scrutiny, I totally agree with Deputy Wallace and others, was the right decision. And we thank the Business Committee for the referral. So we will now be preparing a report. Time frame we're talking about, we'll have a draft in a number of weeks. We'll consider, will we get unanimity? Well, that would be ambitious, perhaps, but we will nevertheless be making recommendations, and that's the process that they...
We'll punch in aside and have a chat with them.
I don't have a problem with it changing it so it's symbolic.
Don't be targeting Jim at all. So, without any further ado, and before I thank our witnesses this morning, I'd like to thank Ms. Caoláin Spring from the Department of Justice and Equality for being here. Thank you. And both Eamon Fahy and Nur Nadia Binta Zelani, I hope I've pronounced that well, from the ESRI. You're both very welcome in the Visitors Gallery. So, without any further ado, I'd like to, on behalf of the committee, thank each of our witnesses, each of you. Judge Catherine McGuinness, thank you very much, Catherine, and lovely to have you before us here in my tenure as chair. We go back a long way, Catherine, we do indeed, and you were in the chair when I used to have to come before you. I'm not in a court, I want to add. No. We were on a peace project. Yes. I'd like to thank Dr. Helen Russell and Dr. Francis McGinnity, both from the ESRI. Thank you very much indeed for being here. I'd like to thank John and Catherine from the Family Carers Ireland. Thank you very much indeed for your contributions here today. And Joan and Hilda from the Irish Country Women's Association, it's been a pleasure having you both with us, and thank you to ICA for all your work. And finally, and by no means least, Pauline, on behalf of Stay at Home Parents Association Ireland, that I get it absolutely right, and thank you very much, and to your colleague Catherine as well, I think, isn't that right? There would have been 3 Catherines here today. We'd never have got through it. But thank you all very much indeed for your respective contributions to this particular matter. So the Joint Committee is adjourned until 9 a.m. on next Wednesday, the 3rd of October. Thank you, colleagues. Goramila.